on the computer. All right, so this is going to be chapter 5. What is real estate? We're finally getting into real estate. When we get into this chapter, we're going to start talking about some stuff that's in chapter 20. So at that point, we're going to then take a little detour off, and we're going to do chapter 20 really quick as well too. So we're going to do chapter 5 and 20 right now. You'll see what I'm talking about in a moment. I'll be opening up that other chapter slideshow as well. But for now, let's get into it. Chapter 5, what is real estate? So you're going to be able to identify the characteristics of real estate, distinguish between what's real property and part of the real estate, and what is considered personal property. Okay, let's start with the bundle of rights. Okay, so nothing really to study here other than understanding what the bundle of rights are. When you buy real estate, what you are buying is the land, anything that's on it, and any rights that the owner previously held that they're going to be passing on to you. Sometimes those rights could have been restricted already too. So when that happens, what are you getting from the person who sold you the property? You're getting from them the property and their restricted rights if they have some restrictions in it. For instance, something that dictates what you can do with the property. So if they're saying that you can or can't do something with the property, well then you could only inherit whatever rights that previous person had. So we refer to all those rights that you inherit as the bundle of rights. So that includes the right of possession or seizin. You don't need to study each of these individual rights, but let's just go over them. The right of possession or seizin, that means to be seized of the land. You're in possession of the property that you own. The right to use the property in any legal manner. The right of quiet enjoyment, to enjoy your premises without being disturbed by others. The right of exclusion, to be able to keep others off of your property and occupying it. And the rights of disposition and alienation. Okay, this term alienation, we're going to see a lot in other chapters as well, even in mortgages. Alienation, to give you the simplest definition of it, I broke it down here, is a transfer of property. If you remember it in that simple definition, then no matter when it's used later on, you could figure out what they're talking about. Now, so alienation, to be able, or disposition or alienations, to be able to sell, give away, let, which is to lease the property or transfer and any of the rights to another person. You have that right if it's your property. So a lot of times when we used to teach these classes, or even when I learned these classes, when I was in your position, first we learned about how real estate worked throughout the world in other countries, the different types of ways that you could own real estate. In some areas of the world where you have kings, queens, and emperors and such, you have something that was called the feudal system. And do you truly own the land that you own and that you're in possession of? No, you'd have somebody, a higher authority like an emperor or king, who granted you the ability to possess and use their land for a period of time. You know, go try to buy land in China. All right, you have to be granted permission by the emperor. Then they give you that ownership of that land for only 60 years. You would have to try to re-up and re-ask for permission to own it for another 60 years after that. So do you truly own the land? No. But in the United States, we have something called the allodial system. And the allodial system is a truer ownership of land where you could actually have more of a say in the property it is that you own, because your ownership is absolute. Of course, that absolute ownership is limited to the rights or restrictions that the government may impose on you, such as taxation and what you could build for zoning, you know. But we gave them those rights. So you got nobody blame yourself for that. But we gave them those rights. So alienation is a transfer of property in its simplest form. Need to know that. Now, this can be voluntary or involuntary. Voluntary is something you wanted, involuntary is something you don't. Here's some examples of voluntary alienation. Selling the property, giving it away, devising it. Devise means to leave the property by will to your heirs. To lease the property or license it. So these are some terms we're going to be learning, obviously, as well. Involuntary alienation examples would be foreclosure or escheat. This is where we're going to go off in chapter 20 here, and we're going to start learning about some of these death terms. Escheat is when you die without a will and no heirs can be located. The state will take your property through a process called escheat. They escheat you out of your property. And then we have a partition. That's involuntary alienation. That's where if you own a property with someone else, they could take you to court and force you to sell it if they don't want to be in that property anymore. If you're not willing to buy them out, you know, they could sell that property, their interest, to someone else. But if they can't find someone else to sell it to, just their partial ownership, and you're not willing to buy them out, they could take you to court and force you to sell the property through what's known as a partition proceeding. And then we have a suit for adverse possession. We're going to be learning about this today as well. Adverse possession. This has to be perfected with what we call an easement by prescription, where if somebody owns or somebody uses someone else's property for a period of time, they can make a claim of ownership on it. So that would definitely be involuntary on your behalf of losing that property, right? So now within these rights are further rights to improve. Devise means to leave by will. Mortgage, encumber, cultivate, explore, mine, build, lease, license, dedicate, give away, abandon, share, trade, or exchange the property. All a bunch of terms that we're going to be learning. So let's turn to the second page there in chapter 5. And underneath those olive branches, you're going to see the word devise on the first line. I want you to highlight devise means to leave by will. And then write a little cross-reference, page 342 above that. Page 342. And I made up this slide here that has a lot of different death terms. And this is where we're going to go off. After I go over this slide, we're going to go to chapter 20 and just do chapter 20, because this is a lot of the stuff that's listed in chapter 20. So we got the word devise here, which is a transfer of property by will upon death. You transfer that property with a will, last will and testament. I have the word demise in here. This is something you'll see in chapter 12. It is not a death term, but these are two words that people commonly mix up and they confuse because they're very similar. Devise and demise. Demise sounds like death, but it isn't. Devise is the one that's where you transfer your property by will upon death. Demise is a transfer of property by lease. Every time that you lease your property to someone else, there's got to be a demising clause in the lease that says that the landlord is to let and the tenant is to take possession of those premises. Then we have testate. Testate is a word that just means that you prepared a will, you have a will. Intestate means that you do not have a will, you have not prepared a will. Testator is somebody who has prepared a will. They're called a testator. That's and if you're a female, you're a testatrix. So the male who has prepared a will is a testator, and a female who has prepared a will is a testatrix. Probate is a legal process to determine who the heirs of an estate are and to determine what the assets of that estate are after all debts have been paid. They mainly want to make sure that all your taxes have been paid before you start distributing to your heirs your belongings after you die, you know? That process is called probate. It's also a process of determining who the heirs are if you didn't have a will or if you had a will, to make sure that those people that you're leaving it to are genuinely those people that you named in the will. So all wills have to be probated when somebody dies. Now, every state also has something that's called the right of descent and distribution. It's a law that determines if you don't have a will, who gets your stuff. You guys interested in that at all to find out? Well, in chapter 20, we're going to go over that in detail. Escheat means that you were not able to find any lawful heirs who can inherit your stuff. So if those heirs cannot be located, the state will sell your property at an auction. They'll hold those funds in a fund for 1 year, and if no heirs step forward to claim it within that year, the state takes the property. A legacy or bequest is a gift of personal property upon death, like you're leaving somebody your car or something like that. The legacy is what you have, your personal property that you've amassed during your lifetime that you're going to leave behind. The bequest is your wishes to who you would like to leave it to. So that's what a legacy and bequest is. You ever hear that like in a movie where they want drama? I bequeath to thee my vast fortune in my bank account of $4. You know, hopefully you have more of a legacy than that to leave behind. But anyway, you know, you get the drift of what I'm saying. And then dower and courtesy, I'm going to get into a little bit when we actually get to it. But these are ancient rights in New Jersey. They're specific to New Jersey. They specify when you're married, what does your spouse get? You know, and this all depends on when you were married. If you were married before May 28th, 1980 in New Jersey, or period, but you live in New Jersey, if you're married before May 28th, 1980, your spouse has dower and courtesy rights. These are rights that are reserved only for a surviving spouse when the other dies. The other spouse has interest in all the property that you own during your life. If you're married after May 28, 1980, your spouse only has interest in the primary marital residence. So that's why it's important to understand when somebody was married. When we as real estate agents are going in to get a listing, does only one spouse have to be signing the listing documents if only one spouse is listed as the owner of the property on the public records? Or do they both need to sign? Well, it depends. When were they married? If they're married before May 28, 1980, even if one is only listed as the owner, well, your spouse still has a right of interest in that property, so both of them need to sign any documents that are relevant, okay? So dower and courtesy are those rights reserved for the spouses. Now, dower is the wife's right in the husband's property upon his death. Courtesy is the male's right in the wife's property upon her death. So we need to know which one is the wife's right and which one is the husband's right. Okay. Dower is the wife's right. Courtesy is the husband. The way I remember this is, you guys know what a doe is?
A deer, right?
A deer, a female deer, right? Doe is a deer, a female deer. Remember that song?
Yeah.
Okay, so it's from an old movie, so some of the younger people may not know that, but doe is a deer, a female deer. So doe is a deer, a female deer. So that's how I remember dower is the female's right, the wife's right, because it begins with a doe, and a doe is a deer, a female deer. And men are courteous to women, so courtesy is the man's right. That's the way I remember it anyway. Dower begins with a doe, and a doe is a deer, female deer. Courtesy, because men are courteous to women, is the male's right. That's the way I remember it. And when is the date that they created any new, or that they stopped the creation of any new dower or courtesy rights? May 28th, 1980. Now, don't worry, we'll be highlighting this somewhere in the book in probably I think it's in the next chapter. If we were to highlight it, it's on page 95. Go to page 95. Since we just went over it, might as well highlight it now, right? This is in chapter 6. Page 95. You see dower and courtesy? Let's highlight the first 3.5 lines there pretty much. Dower is an ancient right under which a wife has certain interest in her husband's death and any real estate he owned during their marriage, she owned during her marriage. Courtesy is a similar right that the husband retains in the wife's estate. As of May 28, 1980, New Jersey abolished the creation of any new dower or courtesy rights. Highlight up to that. Okay. And now we're going to go off on chapter 20 and finish learning about the rest of the stuff that's on this slide right here. So it's going to take us maybe about a half an hour to do chapter 20. So we're going to go off to chapter 20, and that can be located on page 342. We're going to go to. You guys go to. Oh, never mind, not 342. Let's just go to the beginning of that chapter, 339. And let me open up that slide for us. Chapter 20. Okay, so you guys see chapter 20 now up here. So chapter 20. I know we started chapter 5, then we went off to chapter 20. We're going to finish chapter 20, go back to chapter 5. So this chapter, we're going to learn all about those things that we just went over on that slide, and we're going to be highlighting those things that we just went over on that slide. We're also going to describe 4 methods of title transfer, explain the process of transfer of title after somebody's death. What does the word title mean?
Ownership.
Ownership. There's no document in real estate called title. The word title simply means ownership. We learned this in another chapter before. Alienation is the transfer of title to a parcel of real estate. This can be done during the lifetime or after death of a person, and it can be voluntary or involuntary alienation. At death, voluntary alienation would be through the will, their last will and testament. Or if there was no will, involuntary alienation would happen through the process of escheat. So once again, voluntary alienation can be by gift, sale, or exchange. The owner must use some form of deed of conveyance to transfer that property while you're alive. Now, how do you transfer property from or to the government? Well, dedication is when you, an individual, gives your land to the government for a public use, like streets, schools, and parks. This is often done more commonly by a developer. They're going to do a subdivision of land, and they lay out they cut up the land for the houses that they're going to put on, the properties, each individual property that they sell in that subdivision. But what about the streets? Are they going to keep those streets private and have to maintain them? Because those streets are now on private property. They're roads that you paved and maybe named, okay? Well, those, if you're not going to keep them and be responsible for maintaining them and snow removal and repaving of them and all that, you want to dedicate it, that land. That means you're going to give it to the government, and now they're going to be city streets, and the city's going to be responsible for that. Okay, so anytime that a developer is getting their plans approved for any subdivision, part of that is they have to say if there's going to be any land that they're going to be setting aside for dedication to the municipality. Now, public grant is how the government gives you land, a private person. If the government is going to give government-owned property to an individual, they do that through private grant, or I'm sorry, through public grant. That's when the government gives land to an individual for private use. Okay, involuntary alienation is a transfer without the owner's consent. Once again, this can be done through escheat, through eminent domain, through unsatisfied debts when somebody gets foreclosed, or through a court action called a partition proceeding or an action of quiet title. Adverse possession. This is through the process of something we call an easement by prescription. Some people know it as squatter's rights. It's when you've been using someone else's property against their permission for a long enough period of time, you can claim ownership of that property. And we'll be going over that process of how that works, but that's a form of involuntary alienation, right? Somebody's going to take away your property just because they've been using it against your permission for a long period of time. That's why it's important for you to take any action against any adverse possessors using your land to get them off, because there's that possibility where they could try to claim ownership of it if they're there long enough. And then erosion. This is something beyond our control, though. Erosion is the wearing away of land by wind or water. So it's a decrease in land caused by wind or water, by Mother Nature. Wind, water, or sinkholes, or other forms of erosion that could be done. But erosion is usually done gradually over a period of time. It's not immediate. That would be something else. Okay. Now, at this point, we have to give just a little rundown of an easement by prescription, but let's first get caught up on the highlights. On page 339, let's highlight alienation is the transfer of title to a parcel of real estate. On the second line, on the second paragraph, at the end of the line. Alienation, the transfer of title to a parcel of real estate. Everybody got that?
Repeat that, 339.
On page 339, in the second paragraph, on the second line, at the end of the line, you see alienation, the very last word on the line.
Yes, sir.
Highlight alienation, the transfer of title to a parcel of real estate. That's the basis. That's the most simplest definition to understand of it. Then we're going to turn the page. Then we're going to highlight voluntary alienation is the transfer of title that may be made by gift, sale, or exchange. And the remainder of that paragraph and the following paragraph explains different forms of voluntary alienation, but you don't need to highlight all that. Involuntary alienation now, next section, we're going to highlight the first line there. Title to property can be transferred by involuntary alienation, that is without the owner's consent. And then highlight the last sentence in that same paragraph that says, when a person dies intestate and leaves no heirs, the title to their real estate passes to their heirs through the process known as escheat. Wait, did I say passes to their heirs? Passes to the state through the process of escheat, when no heirs can be located. So when a person dies intestate and leaves no heirs, the title to their real estate passes to the state by escheat. Sorry, I'm not reading this. I'm just going from the top of my head, and sometimes I bumble things up a little bit. Just want to make sure I said it right. Okay. These are all terms we need to know. Look, it took us a while to do these first first 4 chapters. We're going to be going through a lot of chapters now with a lot of terminology in them. Those terms, your exams are going to be based off of learning a new language, the language of real estate, and we're going to be learning a new language in 75 hours because this is a 75-hour class, right? That's a pretty big undertaking. Although nothing here is rocket science. When I explain all this stuff, it's pretty straightforward and easy to understand, but it's a lot to remember. So you got to take notes, study these terms, study their definitions, okay? My job is to explain it so you understand it. If there's something you don't understand, you got to stop me and ask me so that I can explain it a different way, perhaps, so that you can understand things. Okay. And then your job is to study it, to remember it all. Okay. So
Okay.
if I explained it to you guys so you understood it, I've done my job. Now it's all on you. So don't go blaming me later on if you didn't pass an exam, you know? That's what I'm saying. We gotta learn what our roles are here. There's a lot of information to take in, and I understand that. You know, I've been in your position before. I was a student. You know, it's just a lot of information to take in. So don't take it at face value that it's no big deal. I'm going to just pay attention here in class and that's it. You know, you need to take these notes and you need to study them too. Okay. So you're seeing we're going to be going through a lot of terms and definitions. You may get a little bit of a headache today. All right. Sorry about that in advance. You may want to take an aspirin at lunch. All right. On page 341, in the second paragraph on the second sentence, we're going to highlight partition proceeding is where one co-owner seeks to force another to divide or sell the property. So if you and I own a property together and I don't want to own the property anymore, am I stuck owning it with you? Well, no, I could try to sell my ownership interests. I'm not selling the whole property because I don't have the ownership of the whole property. I'm selling my interest in that property. But it may be hard to find somebody who wants to take ownership, to buy my interest in the property and become a co-owner with some stranger. So that may be a very difficult task to do. So what are my options if I can't find somebody to buy my interest in the property? Well, I could go to you and see if you'll buy it. But maybe you're like, I wish I could, I don't have the money. Am I stuck owning the property here with you in New Jersey? I mean, I'm looking to sell and get out.
No.
I do have one other option. I'm sorry, guys, but I'm going to have to take you to court. And I'm going to see if a judge will examine the property to see if it can be physically partitioned, to see if it can be physically split into two. And if that is not possible, then he's going to order the property sold. And then the proceeds from that sale will be divided amongst us according to our ownership interest. For 50-50, it's 50-50. Okay. So that's what the partition is. All right. Now, easement or adverse possession. This is what I got here on the slideshow. This is something that we're going to mainly go over in chapter 7 in detail. But they're discussing it here again in this later chapter. So next to the title of adverse possession, I want you to write easement by prescription, like I have it written up here on the slide. Next to the title of adverse possession, I want you to write easement by prescription. Now, this is going to be first mentioned on page 100. So page 100 and this page 341 is the two places in the book that talks about an easement by prescription. And when we get to it on page 100, you're going to see that there are two conflicting definitions about it. And those, what I mean, conflicting definitions. Okay, so let's first go over what an easement by prescription is. That's squatter's rights, some people know it as. It's when you use someone else's property for a period of time as defined or prescribed by state law. You can claim ownership interest of that property if you've used it long enough for that period of time that the law says. Now, who makes the laws? The politicians. Guess what? Our politicians love making laws. And sometimes they don't bother checking to see the other laws that are already there. They just want to create another law, say, I'm a hero, I created a new law. Now they created so many laws on the same topic that they conflict with each other. So an easement by prescription is where you could take ownership of someone else's property if you used it for a period of time. But there are 3 laws on the books. One that says you have to use it for 30 years, one that says for 60, and another one that says it for 20. So nobody right now can successfully win an easement by prescription in New Jersey through a suit for adverse possession, because the law is screwed up, and until the politicians fix the law, a judge cannot make a render a decision. Judges judge based on the laws that the politicians make. Judges don't make the law. At least they shouldn't be legislating from the bench. So right now, nobody's going to be getting an easement by prescription this way. And I've been monitoring this for about the last 10, 11 years now. It's been that long since we've had the conflict on the books, and New Jersey legislators still have not fixed this law. And they know what they want to do. They're going to do away with the 30 and 60 year period and just have a 20-year common law period for the easement by prescription. So which one do you need to study for exam?
I guess all of them.
It depends which answer option they have available for you there. Look, I'm going to tell you currently, I would say go with the 30 and 60 year period, because they introduced this other one, the 20-year common law, later. And I think the state exam is still based on the 30 and 60 years as well. I'm still waiting for a definitive answer from the Real Estate Commission months later. They said they were going to run it by their legal counsel. I reached out to PSI. PSI is like, we can't tell you what's on the exam, but probably because they don't even know. So I don't know. We have got a little issue there then when it comes to teaching. And I brought this up to the Real Estate Commission that no school knows the proper way to teach you this. Even right now, I'm guessing. I mean, I'm taking an educated guess, because from my experience, the exams have been using the 30 and 60 year period, and they have not changed it to the new one yet, even though the book now is starting to explain the new one. Okay, so to perfect an easement by prescription, it requires court action called a suit for adverse possession to actually claim the ownership of the land. So just because you've been using someone else's property for a period of time does not automatically make you the owner. You need to take that owner of the property to court to claim ownership of the land that you've been using. Okay, that's what the suit for adverse possession is. It's a way to perfect the easement by prescription and get that ownership. We're going to see a couple of videos on this today. And I'm going to draw some pictures and diagrams and show you how. I'll make it a lot more clear. I know it's maybe a little bit confusing right now still. So to gain an easement by prescription, the prescriptive period is 30 years if they're improved lands. What is an improvement? It's any man-made improvement to land. And that doesn't need to be a house on the property. That could be they ran sewer pipes under the property, or it could just be a paved road. Those are all man-made improvements. Once you add man-made improvements to land, it is now real estate. So there's 2 distinct differences between what land is and what real estate is, which we're going to be learning in chapter 5 here today. Now, if the land has improvements on it, it's a 30-year prescriptive period that you have to be using that property against the owner's permission for 30 years in order to take them to court and claim ownership of it. Now, if it's unimproved woodlands, there's a 60-year period you had to have been using that property for before you could claim ownership of it. Okay. Now, this wouldn't be mostly for the types of squatters you may be thinking, just an individual who's trying to get off the grid and just live out on somebody's property, right? I'm going to give you an example. This conflict in the law for all these different prescriptive periods came about when one corporation tried suing another, because this corporation had a fence around the other's property for 60 years. And they tried taking them to court to sue them. But according to common law, the common law says that as soon as you reach 20 years, you have to take them to court, even though they wouldn't be able to successfully win, because this law says if it's unimproved woodlands, you need to have it there for 60 years have been using their property. So that's the lawsuit that broke out. Now, this was not just an individual person. This was a corporation that had a fence up there for 60 years. And it wasn't like just over the property line. We're talking hundreds of acres of land. Okay. They had a fence around hundreds of acres of land of someone else's property for 60 years. And they never noticed it until the person took them to court to sue them. This is why it's important to walk the boundaries of your property periodically, sometime every now and then, every couple of years at least, and to take action against anybody who's using or occupying your property without your permission. Otherwise, somebody can claim ownership of it in court. All right, now the use must be, in order to claim an easement by prescription, the use must be continuous, hostile, adverse to the owner's title, their ownership, exclusive, and without the owner's approval. If the owner gives you permission to use their land, you can't claim ownership of it. It has to be against their permission that you've been using it for that long, and they didn't take action to get you removed. Then you could claim ownership of it. Additionally, the use must be visible, open, and notorious. So you can't have like an underground doggy fence on someone's property and say, claim that you've been using their property then for all that time. It has to be obvious that you've been using the property out in the open. It has to be visible, that use. Now, through the process called tacking, one person could add on their time of using the property to another's. Let's just say you were using the property, and then after you died, your son was using the property. You could add both of those people's time period of using that property together. You could tack on one person's time to the others to reach that prescriptive period to take them to court and claim the ownership. They just had to be successors in interest. You know, successor in interest could be, you know, a relative, like a father and a son, or a seller and a buyer. There has to be some sort of a link between the parties to tack on one party's interest to the other. Now, the ways that an owner can prevent somebody from taking the ownership of their land is an owner can take legal action to remove any adverse possessor. They could cut off their direct access and stop the continuous use of their property. That would reset the time clock back to zero. Because remember, in order to claim that ownership, that easement by prescription, the use had to have been continuous. So if you cut off their access, it's no longer continuous. You reset that time clock. And you give them permission. So let's just say that person's been using your property there for the last 60 years, and now you just find out they've been using it, but they haven't taken you to court yet. Remember, in order to claim ownership, an easement by prescription is not automatic. They got to take you to court still. Let's just say you just found out they've been there that long and they could take you to court. Instead of waiting around and hoping they don't, you could send them a certified letter giving them permission to use the property now. As long as they didn't file that lawsuit yet, you gave them permission to use the property. Now you reset the time clock and they can't claim the ownership because you gave them permission to use the property. So these are the ways that you could prevent an easement by prescription from occurring. See how it's important to understand what's going on your property? If it's your land, you should walk your land at least once every couple of years and then make it, you know, make sure that anybody who's squatting on your property gets the hell off of it. Call the cops, get them removed. If that's not working, take them to court. You have to take some sort of action to remove any adverse possessors. All right. So let's do the highlights here. Third line down, we're going to highlight in New Jersey, a person may acquire under adverse possession. In New Jersey, a person may acquire title by adverse possession through the continuous, open, notorious, hostile, and exclusive occupation of another person's property for 30 years, 60 if woodlands. Okay, now if they've used the property for that long, the following sentence, I'm not going to have you highlight it, but the following sentence says it basically, you don't automatically become the owner if you used it for that long. You have to perfect this easement by taking them to court to gain the actual ownership. Okay, now in the margin to the left of what you just highlighted, make a little notation for yourself. There is a 20-year common law period that conflicts conflict in the law. There is a 20-year common law period conflict in the law. Page 100 is the cross-reference where you'll see that. So in the margin where you wrote, where you highlighted 30 and 60-year period there, right? There's a 20-year common law period conflict in the law. Page 100.
Can you repeat that one more time?
There is a 20-year common law period conflict in the law. There's a 20-year common law period conflict in the law. Page 100. See, it's one thing learning this stuff in the books, but I'm also teaching you everything's not so black and white. We got politicians that make laws up like crazy, you know. And sometimes we already have laws to cover topics. And instead of going in and changing the existing laws, they go and they create a new one. You see it right now at our southern border. You know, we've got this this thing at the border, right? We got border crossings, and you got politicians talking about we should make laws about immigration and crossing the border. We already got laws about that. You just need to enforce them. You know, there's no need to create new laws. We hear it on the news every day now, right? This is just another example of it. Except this one is in New Jersey law. This isn't a federal law. This is New Jersey. All right. Now, through the process known as tacking, let's highlight tacking. In the next paragraph, we're highlighting tacking. Continuous periods of adverse possession may be combined by successive users. And then in the next sentence, let's highlight this process is not automatic. Legal action is necessary to perfect the claim. And then underneath that, we're going to write suit for adverse possession. That's what the legal action is called. It's called a suit for adverse possession. Like I have written here on the slide, if you need to know how to spell it, suit for adverse possession. Suit for adverse possession, right here, second bullet point. Okay. That's the actual lawsuit, what it's called, suit for adverse possession. And the purpose is to quiet title. That means, what is title? Title is ownership. Quiet title means that there's somebody who's trying to make a claim of ownership on your property. You want them to be quiet. So sometimes they refer to it as a suit to quiet title. You want to shut the other person up that's trying to claim ownership. So you're trying to quiet them down. Suit to quiet title, or suit for adverse possession. Okay, so suit for adverse possession, that's what you're writing there. Okay. Next, how do we transfer a dead person's property? Well, first of all, let's highlight those statements about intestate and testate. Highlight intestate without having left a will, And then the line below it to the right, we're going to highlight testate has prepared a will. Remember a couple slides back, I had a whole slide with all these terms on it and all these definitions in one neat spot that you could print out and study. Or we could be in chapter 5 and chapter 21 and study these words that are spread all over the place. Remember? Here. Where is it? Oh, I actually have it in chapter 5 slideshow. Where is it? Right here. This slide, remember chapter 5 slideshow? I think I had this also at the end of chapter 20, but this has all those words and their definitions all in one place. Okay. These are the things we're highlighting right now. Okay, so let's highlight, you highlighted intestate without having left a will. Testate has prepared or left a will. Then we're going to highlight probate. Once again, these are all the words that are on here. Probate, you see it's on here. Let's highlight probate or administration is a legal process by which a court determines who inherits the property of a deceased person and what the assets of that estate are. Of course, after all debts have been paid. Now, on my definition list, I have here, I'm talking about, let's see, I talk about a testator and testatrix. Well, over here, they also have an executor or administrator, okay? These are some additional terms, death terms, I guess, executor and administrator. Executor is somebody that you named in a will to carry out your wishes, somebody that you named in a will that you trust. To carry out, their job is to make sure that all your assets are distributed according to your wishes as you wrote in your will. That's what an executor is, or an executrix if they're female. An administrator is if you didn't name anybody in your will to be an executor, the court will assign or appoint somebody that task, and they're going to call them an administrator. Or if you didn't have a will, an administrator, somebody who's named by the court to determine who the rightful heirs are and to make sure that their assets get distributed according to the law to them. Okay.
Okay.
So let's go back to this one. Okay, so this one was talking about testate, intestate, title deed. Okay. Now, a deed is how we transfer the ownership of real estate, but a deed is only good while you're alive. It's not used to transfer ownership after you die. How do you transfer your real estate and your other assets that you've owned after you die?
A will.
Through your will, your last will and testament. So a deed is not valid when you're dead. So if you were selling me your property, for instance, and you signed the deed, when does the transfer of ownership take place? Upon delivery and acceptance of the deed. If you never gave me the deed while you were alive, you signed it, but you never gave it to me, the transfer never took place. So now the ownership would get transferred according to your will. Okay. Now you see here's the same slideshow that we had here in that I put in chapter 5. And here's something else. Testatrix, the person who made a will. Okay, I had that here. Testator, testatrix. We just needed to add a couple more terms. What was it? Executor and administrator. Just going to add them here. Executor versus executrix versus an administrator. Hold on one second. Got to get into edit mode of that slide. Versus administrator. Okay, so I'm going to add those definitions later to this slide. I'm not going to do it right this moment because, well, we're learning right now. So I will update this slide. I'll update this slide with these things. We already have the test date tricks on the previous slide, but OR versus EE, this is something that we're going to learn about in chapter 6 or 7. There's a chart there. Executive versus executive tricks. OR versus EE. Hold on one second. I may actually have an image that I could put in here for that. OR versus EE. All right. Make a note to find that because I don't have that here. All right. Just made a note for myself just to add an image there for legal terminology. When we understand legal terminology, words that end in OR versus words that end in EE. If the word ends in OR, that's the person who's giving whatever the root word is. If the word ends in EE, it's the person that's getting whatever the root word is. One example of this could be a lease. We have the word lessor, lessee. You guys ever hear those words before? The lessor and the lessee?
Yeah.
Well, if the root word is a lease, what are we talking about? Renting, right? The lease contract. So the lessor, words that end in OR, is the person that gives whatever the root word is, the lease. Who gives the lease?
Lisa.
The
Lessor.
lessor, which is the landlord. The landlord gives the lease to the tenant, so they're the lessor, and the tenant's the one who receives the lease, so they're the lessee. So here's an example about understanding legal terminology. We'll see it better in chapter 6 or 7 when we actually go over it there. But but I'm also going to add that image to this slideshow. I just made notes of it for myself to do that. Okay, so chapter 20, that slideshow is done, but we're not done with chapter 20. So probate, did we highlight anything under probate there? Probate or administration is the legal process by which a court determines who inherits the property of a deceased person and what the assets of the estate are. So you should have that highlighted and then turn the page. All right. We're going to highlight on page 342, a last will and testament is an instrument made by an owner to voluntarily convey title to the owner's property after their death. How do we transfer ownership of real estate while somebody's alive?
A deed.
Good
By
deed.
deed. How do we transfer ownership after they die? By last will and testament,
Testament.
their will. So a party who makes a will, once again, we're just highlighting this again. A party who makes a will is known as a testator, or if they're a female, they're a testatrix. The gift of real property by will is known as devise. So what is a devisee? It's the person who receives the real property through the will. If devise is the leaving property by will. A divisor is the one who left you that property by will, because words that end in OR is the one who's giving it, right? And the devisee is the one who's receiving it. So divisor and devisee, right? Then highlight a party who makes a will is known as, oh, you already did. All right, and then they talk about in that same sentence. So I put a highlighted box around the rest of the same sentence instead of just highlighting it. A person who receives property by will is devisee. A gift of money or other personal property is a legacy or bequest, and the person receives the property is a legatee. You don't need to know legatee, but legacy or bequest, sometimes they give on state exams, sometimes. So this is a portion, this is a section right here where we're talking about the devise, divisor, devisee. In that, next to that paragraph, I want you to write a note in the margin. Remembering legal terminology, right? Remembering legal terminology. OR versus EE. So have OR in all capital letters versus EE. Words that end in OR versus words that end in EE. Page 108.
Next to what? Which paragraph?
Next to the paragraph, the second paragraph that says where we talk about devise, divisor, devisee.
Okay.
Because there's a chart on page 108 that talks about the legal term, those legal terminologies. Okay. Now, the third paragraph, just put a little bracket with your pen next to it. It says, in New Jersey, children can be disinherited, so be good to your parents. But a surviving spouse is entitled to at least 1/3 of your estate. And the determination of the augmented estate is a complex calculation. In a case where a will does not provide the minimum statutory inheritance, the surviving spouse has the option of informing the court that they will take the statutory share rather than the lesser share that was provided for in the will. This practice is called the right of election. Highlight right of election, right of election. This is this is a right that's only reserved for surviving spouse. So basically, you can't write your wife or husband out of the will. Well, you can, but if you do, if your spouse knows the law, they could just go to the court and say, do I take nothing or a lesser amount that you were required to leave me as a minimum? Or do I impose my right of election to take the 1/3 of everything? What do they call that? That's the right of election. That's reserved only for a surviving spouse. So basically, if you try to write your spouse out of the will or give them only a little something less than what the law requires you to, they could either take that you left them, or if they know the law, they could be like, nah, I'm gonna impose my right of election, take 1/3 instead. Okay, that's basically what they're saying here. Now, how is a will different from a deed?
A will is passed when you're dead, and a deed is when you're alive.
Yes, a deed is how you transfer property while you're alive. A will is how you transfer a property after you die. Correct. So we go. I'm just making notations on my on the slide here that I'm going to be adding all that information into the slide itself, just updating this slide a little bit. All right, so now in order to make a will in New Jersey, you need to be at least 18 years of age. Anybody here have a will?
Yes.
Not yet.
Anybody here own stuff? Have a bank account?
Yes.
Anybody
Yes.
here have kids?
Yeah.
Not yet.
Okay. Well, the reason why I'm asking is, you know, we get a lot of times people who have kids or people who have assets, people have stuff, right? All right. So forget about people who don't have kids. Okay. What about those who are single? Do you have belongings? Do you have money? Do you have a car? Do you own a house? Do you have anything that you own of value?
Yeah.
Yeah.
When you die, do you want to give it to the government?
No.
Nope.
No.
Then write a will.
I wouldn't. I wouldn't.
Then write a will.
So Victor,
You
question.
could handwrite an entire will. A handwritten will requires no witnesses and is a valid will in New Jersey. We call it a holographic will. If you use like Quicken Will Maker or one of the softwares to do it and print it out and then just sign it, that requires 2 witnesses, and those witnesses' signatures should be notarized as well for that will to be valid and to be able to not have issues when trying to present it later on. Go ahead, Christina. What were you asking?
So you said about, you know, the will, but let's say I own the house, but I still obviously have the mortgage on it to pay.
That's right.
So that's fine to make a will?
Yeah, absolutely. Yeah, you own a house or you own a car that still has payments on there. Well, you got a lot of equity in it. You just got to finish off making the payments on it.
So it's,
Look,
I thought
look,
maybe it's
if I'm your kid, right, and I inherit your house and you still owe money on it, can I sell that house, pay off what you owe, and then walk away with a lot of cash?
I guess.
Okay, so yes, you don't have to own it outright, paid off free and clear, because that I
Oh,
believe
okay.
is what your question was, right?
Yes, yes.
Yeah. Okay.
I was wondering, because I was thinking about the will, but I was like, I mean, I only have the house, yeah, car, but car is not that, you know, young.
It doesn't matter. It
Yeah,
doesn't matter.
right.
You have to state who gets what. Now, it's a good idea to have a will, because if you have a will, look, let's just say that you have kids, okay? Do your kids inherit your stuff when you die if you have no will?
Yes.
My
Yeah, they will.
personal, yes.
But wait, even though they're the rightful heirs to get your
Yeah,
stuff,
yeah.
it's gonna be a lot harder for them to get it. It's got to go through the court system to get it. So the court's going to have to appoint an administrator. That administrator doesn't work for free, so they're going to get a big chunk of it. And at the end of the day, your kids are going to get a lot less than they normally would have if you had simply written a will.
I'll do this today.
Okay. Listen,
Because you never know.
you could do something. Look, I did this the other day. I mean, I don't want to show it to you, but look, I got one here that's this is actually a will that I made the other day, because I teach this class all the time. I'm like, shit, you know, I got to get around one of these days to making a will. So the other day, I just hand wrote one. You know, it's a full page. Okay, I just made a handwritten will. Okay.
So do you include, like, let's say jewelry or your motorcycle? No, yeah, motorcycle, yeah, you will.
Yes.
But like jewelry.
Yes, I say all. You know what? You could refer to it just simply as this. You don't need to name every single one of your assets. You could, you could, if there's some assets that maybe they may be unaware of, like a retirement plan somewhere, or you have stocks somewhere, you know, that they may be unaware of. You could name it there in the will, but you don't have to name all your assets. You could just say all my tangible and intangible assets, the real and personal property.
Mm-hmm.
And I want my real and personal property to go to this person. I want my personal property to get divided up according to this. This person gets a third, that person gets a third, that person gets a third. You know, like you can break it up like that. You don't have
So
to
like
give,
investment accounts would be like personal property,
what's that?
or is it investment accounts and stuff like that?
Investment accounts, money, clothing, cars, tools, all that is personal property. There's only two kinds of property in this world, personal or real.
Yeah, okay,
Okay, real is real estate.
right.
So let's say, and for me and my husband, we should do separate wills, or
Yeah,
we can.
Each
be,
person, yeah, each person
person.
has to have their own will. Like if you're married, you have to, state, you don't want your kids getting everything when you die. Maybe you want your husband to get it because he's the adult, and then it would go according to his will. Okay, so basically, you do things like this. Upon my death, if my husband should survive me, not predecease you, but if your husband should survive you by at least 90 days, then your husband will inherit all of your assets. But in the event that he doesn't survive you by 90 days, then your children will get all of your assets. You could just say all my assets, or you could say all my assets with this particular split, or this person gets this. Like if you wanted one child to get a charm or a necklace or something, you could state that they get that, and the person gets that, or you could get specific if you want to, but consult with an attorney.
Yeah, because it's interesting how you can, especially when whoever will survive.
On mine, I just wrote on the top a title. I wrote last will and testament, and I put the date that I'm writing it. And then I wrote my full legal name. I put my date of birth, where I was born, and my social security number there. I probably don't have to do all that, but I did it anyway. All right. And then I put down, about who gets my stuff, what stuff I want them to get. How about, what do you want them to do with you?
Oh, I know. My husband knows already. Burn me.
Okay, well, some people are like, oh, I don't want to get burned. I don't want to get cremated.
Right,
I want to get
absolutely,
buried
yes.
whole in the ground because, what if I'm not dead? People get freaked out about that stuff. So they're like, oh, I want to be buried all together. I don't want nobody to fry me.
Actually, yeah.
Okay, so yeah, but you got to specify that. Okay, now if they cremate you, what do you want done with your ashes now? Who do you want to get your ashes now?
Okay.
There's another consideration. Don't just say, I want them to burn me.
We discussed that already. After my death, what he's gonna do with my ashes?
If you want to be buried somewhere, where it is you want to be buried,
Okay.
if you have a life insurance policy, why don't you tell them, let them know? Because usually life insurance policies are only good. They can only be claimed within so many days, after your death, so you should make sure somebody knows that you have one and where that information is. My dad always had a briefcase. We don't know what was in it, but we knew all of his important documents were in there. So when he died, we were like, we go to the briefcase, that's where his important stuff is, so you should have a safe. If you have a safe, make sure somebody else got a combo to it. They can get into it, right? But be able to have access to that will. It's important to. And list all the people it is who that you want to inherit stuff, who they are, in a way that they can be readily identifiable. All right. Consult
Thanks.
with an attorney on all that stuff though, but you guys could get Quicken Will Maker or some kind of software like that too. That's usually legal in all 50 states, but those type of wills require 2 witnesses and their signatures need to be notarized. If you completely handwrite the will, it's called a holographic will. It does not require any witnesses. And video wills, although they're good for drama, maybe you want them to hear your voice and see you for the last time, to be a little more dramatic like they are in the movies, they're not valid as wills in New Jersey. It has to be in writing, okay? So you could sit there, have your written will, and now read it on video if you want everybody to see you for one last time, and then say, for you, you'll get nothing. No zoop for you. Nah. You really want to stick it to somebody anyway. One last time, right? Okay, so let's see. In the last paragraph under transfer of title by will, 3rd line down, we're going to highlight, to be valid, a deed must be delivered during the lifetime of the grantor. Who's the grantor? The one who made the will.
Yeah.
How do you transfer your property to someone else? By grants. So the grantor is the one who granted you the ownership, and the grantee is the one who's receiving the ownership. That's how we transfer our, that's what we call the people who are giving and receiving property. I'm granting you the ownership. The grantor is the owner, the grantee is the buyer. Grant is how we transfer the ownership. All right. Now, I just went over the legal requirements for making a will. Let's just go down to the second paragraph on the last line and highlight: a holographic will is a handwritten will with no witnesses. Doesn't require any witnesses, and it's now legal in New Jersey. All right, so what happens to your property if you die without a will?
Goes to the government.
No, it should go to your family, heirs if you have any, and if you don't have any,
Well,
then
how
it
do
goes
you,
to the government by a cheat.
all right, well, how do you know who's an heir? All right, we're gonna go over that right now. Okay. Hold on, let me just pull up something. I may be able to put a slide up and put something on the board here from the book. Let's take a look. Yes, I do. Look at that. And I hit that nail on the head first time. Okay, so I'm gonna put together a slide, one more slide here. Okay, transfer of property by descent and distribution. Every state has their own laws about descent and distribution. So, descent and distribution, which determines who gets your assets if you die and you did not prepare a will. All right, so this is what this is what we're going to be going over right now. And hold on, I'm putting a slide together, so give me 2 more seconds. There we go. Almost done, almost done. Just want the slide to be readable. I'm trying to make it big enough here. There we go. It's up on screen. Oh, wait. So descent distribution, once again, this only happens when you die without having prepared a will. Just looking for another slide really quick for this. Okay. Ooh. All right, good. I found the other part, so give me 1 more second with this. I'm gonna pull up everything that I have on screen, or that we're gonna be reading right here from the book. All right, so this is what we got here in the book. Okay, so transfer of title by descent. This is what I'm reading to you. Title to real estate and personal property, and personal property of a person who dies intestate passes to their heirs under the descent statutes. And the primary heirs of the deceased are their spouse, civil partner, or domestic partner, and close blood relatives. When children have been legally adopted, most states consider them to be heirs of the adopting parents, but not heirs, of the ancestors, but not heirs of the adopting parents. So in most states, illegitimate children, all right, let's stop there. What is an illegitimate child? It is if your child was born and the parents were not married. In Game of Thrones terminology, it is the bastard child, all right? So, so the illegitimate child is if you have a child that was born and the parents were not married. So illegitimate children inherit from the mother, but they do not inherit from the father unless he admitted parentage in writing or parentage has been established legally in some other way. So unless he signed a birth certificate or there was a blood test done or something that in some other way he either admitted to being a parent or it was proven in some other manner. Then that if he legally adopts that child would inherit as an adopted child would. They would inherit from the father, but not the father's side of the family, which is kind of messed up, seeing as that is your true child.
Yeah.
You would inherit like an adopted child. From your adopted parents, you could inherit from your adopted parents, but not from their side of the family. Now, of course, if you have uncles and stuff like that, and they wanted to leave you something from their wills, they could name you in their wills, but you cannot claim that you're a rightful heir to an uncle if you're adopted, or if you're not adopted, if your parents were not married, you cannot claim to be a rightful heir from the father's side of the family, even though you may be, because you're blood relatives. But if your parents were not married at the time that you were born, you could only inherit from the father, not from his side of the family. So your claims won't pass muster. So intestate real property is distributed according to the laws of the state in which the property is located. So New Jersey law of descent distribution provides that real property belonging, I don't got it all there, belonging to an individual who has died intestate is distributed in the following order. And that order we're going to have here in just a second. Sorry, apparently I cut that off from my my picture here, but I'm going to snap another one. All right. Email that to myself real quick. And add it to the slideshow. Okay, so the laws of descent come into effect only when the descendant leaves no will. A surviving spouse or partner become the sole heir if the descendant leaves no parents or children. If there is a child or children who are also the children of a surviving spouse, the spouse or partner receives the first $50,000 plus 1/2 of the remaining estate. The rest goes to the child or children. If the descendant leaves parents and a spouse but no children, the spouse or partner receives the first $50,000 plus 1/2 the remaining estate. The rest goes to the parent or parents. If there are children who are not children of the surviving spouse, perhaps from a previous marriage or relationship, the spouse or partner receives half the estate and the child or children the other half. Where no spouse or partner survives, children become sole natural heirs. And where neither a surviving spouse nor children's own heirs, the state The estate first goes first to parents, and failing that, to brothers and sisters or their heirs. In default of any other natural heir, grandparents, aunts, uncles, and first cousins may be considered heirs. But beyond that point, the entire estate goes to the state of New Jersey by escheat. So the state treasurer, so how does escheat work? The state treasurer sells the property at a public sale, giving notice by publicizing it in the local newspaper and in Trenton newspaper. So a local newspaper in the county where the property is located, as well as in Trenton. The proceeds of that sale are then held in a fund for 1 year, and if no claims are made within that year, the funds then belong to the state. They take the money. Now, if you guys want to see if there's anything that's maybe due to you from relatives or due to any of your other relatives, there used to be this one that we were using, missingmoney.com. However, New Jersey, our governor pulled out of it recently. We don't use this site no more, but still search. You could find things in there for yourself and other people. Other states are still using this. New Jersey now is exclusively using this link, unclaimedproperty.nj.gov. I want you guys during break to look up your name, your relatives, brothers, sisters, mothers, aunts, uncles. I guarantee you at least one person in class is going to find money. We always find at least one person who finds missing money to them in this class. And this information I share with you right now, for a lot of people, has paid for this class in itself. Look, I had one girl here. She didn't think that she would have found anything. She's like, well, I mean, I graduated from high school and now I'm taking this class. You know, it's like she found money in when the state was still using missing money. She found money in there from her last employer. He never turned her. She worked at Hot Topic in the mall. They never gave her last check. Instead, they gave the money to the state. So her name was in there under the missing money. Well, now it would be unclaimed property. And she got that last check, a couple $100. You know, so even somebody young that didn't expect to find anything found something in there. So if you find anything in there, there's only a 10% finder's fee, okay? But you don't want to share? No, that's all right. Okay. But anyway, these two links are very, why don't you write them in your book? Write them in your book underneath this on page
But
340.
New Jersey doesn't use missing, or you still want
New Jersey does not use missingmoney.com anymore, but you may still find things because a lot of other states do. So I would search both of them. So exclusively for New Jersey stuff, you would go to www.unclaimedproperty.nj.gov. And you could search the database there. You know, some people, they buy bonds, you know, and bonds have to mature. And so out of sight, out of mind, sometimes people forget about them. And if the bank never reached out to you, a lot of times they don't, to come claim your bond, they just turn it over to the state. When my dad was alive, that happened once. He bought a bond and he forgot all about it because they tore down the branch and that branch sold and they tore it down. The bank wasn't even there anymore. So I guess he forgot all about it. He had to wait a couple of years for it to mature anyway. And I was searching this website, missingmoney.com, and I found that he was due like $5,000 or something like that, 5 or 10 grand there, because of bonds that he bought. And he forgot all about it, out of sight, out of mind. Boom. I found it for him. We were able to download the claim sheets, submit them, and then he got his money. Boom. Okay. All right. So we're done with chapter 20. Let's do the key terms for chapter 20 now. Okay. All right. Transfer of title with the grantor's consent. Transfer of title with the grantor's consent. We're on page 344, doing the key terms. A transfer of title with the grantor's consent.
Is that No.
Voluntary alienation.
It is voluntary alienation. 13 is A.
Hmm.
Voluntary alienation, 13 is A. Acquiring of property by natural heirs.
Descent.
That's descent. 3 is B, descent. Court proceeding to establish the validity of a will.
Adverse process.
No, what do we call the court proceeding? That establishes the validity of the will. It determines who the heirs are and makes sure that all debts have been paid.
Probate.
Probate, 10 is C. A document disposing of property after one's death.
9.
9 is D, last will and testament. 9 is D. Having made a will. What do you call it when somebody has prepared a will?
Testate.
11 is E, testate. What do you call the person who makes a will? Testator. 12 is F. One who can inherit.
Heir.
Heir.
Heir. 6 is G. One who receives property through a will.
Devisee.
Devisee. 4 is H. Person named in a will to administer the descendant's estate.
Administrator.
Administrator.
No, the person that you name in a will that you want to.
Executor.
That's an executor. 5 is I. Title acquired by usage.
Adverse
Adverse
possession.
possession.
Yes, it is. 2 is J, adverse possession. A transfer of title without the grantor's consent.
Involuntary alienation.
Voluntary alienation.
8 is K, correct. Without having a will or without a will. You died without a will. What do we call that? Intestate. 7 is L. Person named by the state to administer a descendant's will.
Administrator.
That's the administrator. 1 is M. All right. Now we could go back to page 84 in chapter 5.
Four.
Yep, go back to page 84 in chapter 5. Okay, so let me pull up the slide for that.
Excuse me.
That's all right. I understand. It's boring stuff. All right. But you know, it's interesting to find out, you know, who gets your stuff, you know, after you die, you know, and how it's distributed, you know. So if you did not have a will, this is how it determines who gets your stuff. Right?
Yes, sir.
Maybe it's not exciting for some. I don't know. Interesting to know nonetheless.
It is.
It is.
Because you're gonna need to know, because we're all going to die at some point in time. Sorry to be the bearer of bad news here, but you know, it happens. So you know, it's life.
The
So,
worst thing is if it's suddenly and somebody is not prepared.
well, you're never prepared, are you?
No, I mean,
Yeah.
Exactly.
So life's an adventure, I guess, and we don't get to say how long we're here to enjoy it. So enjoy it while it's here. You know, that's why I say good karma, you know, don't hold grudges. You know, it's life's too short to be bitter. So, you know, somebody pisses you off or gets you angry, your blood pressure goes up. Why? Come on. We're all here for so long. You know what? Just enjoy your life. Don't let the little stupid stuff take over your life and be a bitter person, you know. Go outside, breathe the fresh air, enjoy the sunlight, go to the beach, go boating, enjoy the outdoors, enjoy your kids, enjoy your family, and live life. All right, that's all my 2 cents. So back to chapter 5 slideshow. Here we go. Land. What is land? So on exams, you'll need to know what the difference between real property and land is. Oftentimes we use both these terms, land, yeah, I want to buy land, or I want to buy real estate. Often we use these terms interchangeably to mean the same thing, but there are distinct differences between the definitions. So land, according to the book here, refers to the Earth's surface, including the water and anything permanently attached to it by nature. Everything extending downward from the surface to the center of the Earth and upward to infinity. And this would also include any subsurface rights, air rights, and water rights that may go with it. So in the second paragraph under land, we're going to highlight, thus land may be defined as, we're going to highlight those 2 lines there. Now they also refer to a parcel here. They use this term parcel, which I'll put a definition to it here, even though I don't think you'll get a particular definition on parcel itself. Let's put down, what is a parcel?
Parcel.
It is a specific tract of land, with legally defined boundaries. All right, so let's see, did I save that? Should be updated on the slide. Okay, so here, parcel is a specific tract of land with legally defined boundaries. Okay, and they pretty much have that written there. I don't think you're going to see this as a question in itself on exam, but hell, it's terminology, it's real estate terminology, so you should know what it is. So we're not going to necessarily highlight it, but it's right here. A specific tract of under land, the last sentence. So a specific tract of land is commonly referred to as a parcel, which can be of any size, but has legally defined boundaries. Now, the term real estate, okay, we have land, we just went over that. But real estate, what is it? The definition of real estate is land plus all man-made improvements, structures, sewers, water pipes, paved roads, etc. It includes the subsurface rights, the air rights, and the water rights. I put this definition here. I have 2 definitions for real estate right here. Okay, I have the definition of land here and everything on one slide, including my cheesy little drawing. Those are not hands sticking out of the earth. That's supposed to be a tree. That's supposed to be a bush. That's supposed to be grass. Okay, see, I wrote trees, bushes, grass. So the term land and real estate are often used to describe the same thing, but they have important differences in their meanings. Land is the surface. Here, look at my definition. I think it flows better than the book, so you tell me. Land is the surface of the earth, including water and anything permanently attached to it by nature, which does not require annual cultivation, like grass, trees, and bushes, and everything below the surface to the center of the earth, and everything above it to infinity. So everything below the surface of the earth to the center, and everything above it to outer space or infinity, however you want to define that. Now, does that mean that you could stop planes from flying over your property? No. The FAA, the Federal Aviation Administration, has exclusive jurisdiction over everything above 500 feet above the highest point of your land. So you own everything to infinity, but they could decide what flies over it. All right, now real estate. I have two definitions for it that mean the same exact thing. It can be described in two ways: land plus man-made improvements plus all the rights, interest, and benefits that go with it. But what's another way of saying all rights, interest, and benefits? Bundle of rights. So it could be described as land plus man-made improvements plus the bundle of rights. So there's the two ways that you could describe it. You could either spell out all rights, interest, and benefits that go with it, or you could just say the bundle of rights. But I'm not sure how they mention it on exam, but they will. So you need to know the difference. What's the difference between land and real estate?
Real estate has man-made improvements.
It's the definition of land plus man-made improvements and your bundle of rights. Okay. So how do you identify a piece of land if a property is land or real estate? Land is the surface of the earth and all things permanently attached to it by nature that does not require annual cultivation, meaning you don't have to plant it every year to come back, like trees, bushes, and grass, or perennials. Perennials are flowers that when you plant them, they come back their own every year. You don't have to plant them again, versus annuals, you know. And so real estate would also include, that's not a rocket ship, that's supposed to be a house. Yeah, my drawing skills are limited, okay? Don't knock them. All right, so you do need to know this. You will get questions on school and state exams, knowing the difference between the two. And they could give you an explanation and ask you, is this land or is this real estate? Or what are characteristics of land versus real estate? There you go. All right. So under real estate, we're going to highlight on the first line towards the end of the line. Man-made improvements, then go to the next line, include both buildings erected on the land and streets, utilities, sewers, and other manufactured additions to the property. So that is what an improvement is. Real estate, we're going to highlight that last sentence there. Real estate is defined as the Earth's surface extending downward to the center of the Earth and upward into space, including all things permanently attached to it by nature or by people, and all the rights and benefits that go with it. And underneath that, where it says rights, benefits, and interests in it, right just beneath that, the alternative way of saying it, bundle of rights. Bundle of rights. Okay. Then at the top of the next page, we're going to see corporeal assets. You guys ever hear of the term tangible? You guys know what the word tangible means? It's something you could touch or feel. If you could put it in your hand and you could touch it, you could feel it, it's something that's tangible. All right, so corporeal is just another word for tangible. So a corporeal asset is a tangible asset, something you could touch or feel, like buildings or trees. However, something that is incorporeal or intangible can have value to it as well, even though it's something you cannot touch or feel and you cannot hold in your hand. Like a beautiful ocean view, would that add value to your property?
Yes.
Or a beautiful
Absolutely.
mountain view, but you can't touch it. But it's still so these are what we refer to as intangible or incorporeal assets. There's something you cannot touch and hold and, transfer to somebody, but they do have value to them. So another example, of an intangible asset is something you cannot touch, yet it may have value, like views or your rights. Anybody ever watch Cops before? Knows people always know their rights, right? I know my
Yeah.
rights. And they're getting pulled over and arrested. Right? I know my rights. So there we go. So do you value your rights? Well, it seems like when you're getting arrested, you do, but rights, you have rights to real estate too, right? Air rights, water rights, subsurface rights, mineral rights. So you cannot touch your rights. Let me give you another example of your rights. A lease is considered personal property that is an intangible asset. Although you can't touch the paper the lease is printed on, the lease signifies the rights that a tenant has to occupy and possess someone else's property for a limited period of time as defined in the lease itself. So a lease is an incorporeal, intangible asset. Okay, so this is another example of your rights. Would be a lease. So I'm gonna just write here. So just another example of your rights would be a lease. All right. So the lease is an intangible, incorporeal asset that is considered personal property. A lot of times, people would maybe ask, a lease, is it considered personal property or real property? And people say real property. And then my answer is, why? Do you own the real property?
Nope.
Then it's not real property. So it's got to be personal. Now, is a lease tangible or intangible? Now, a lot of people say tangible because I could touch the lease, I could hold it in my hand. Well, no, it's what does the lease signify though? It signifies your rights to occupy someone else's property for a limited period of time as defined in the lease. So you see, a lease kind of requires a little deduction. You got to ask yourself some questions about it in order to get down to the nitty gritty of it, right? Is it real property or personal property? Well, you don't own real estate, so it's not real property, it's personal. And even though you could touch the paper it's printed on, what does it signify? It signifies your rights. So in that regard, it is intangible or incorporeal. These are pronounced not corporeal or incorporeal. It's incorporeal. There's another O in there, corporeal. I had a student point that out to me one time, so I'm going to make sure I'm teaching it to you guys. Right? Sometimes I say corporeal. It's not corporeal, it's corporeal. An interesting thing is you'll see these terms used sometimes now. If you guys study them and you guys remember them, sometimes you could be watching a Netflix series or something on TV, and you're going to hear some of these terms being used, and you can be like, I know that term. I learned that in class. Good, if you remember it.
I have a question.
Uh-huh.
Because, normally when I think of like assets, I think like, oh, you're able to sell it, but are you able to sell a lease?
You may be able to transfer the lease, maybe. That's a big maybe.
Or like, Because like, so then how's it, is it just an asset just because you own it?
Well, you don't own it. A lease
Well,
is
like just,
your rights that have been given to you, that you own them for a limited period of time. You only have
Yeah.
those rights for a limited period of time.
Mhm.
Now, what are the rights that you have? Well, it depends what it says in the lease. And how long do you have those rights? Well, it depends what it says in the lease. So can you transfer those rights to someone else?
depends on the.
It depends if the landlord gave you the ability to do that in the lease. If they didn't, then you can't. And often they don't. Okay, we call that assignment. Assignments when you're allowed to assign your rights to someone else. And a landlord may not allow you to assign those rights. And often, instead of calling it assignment in the regular world amongst regular people that are not in the property field, they call that subleasing.
Okay.
Subleasing or subletting. It's another way of saying assignment. You're assigning your rights in the lease to someone else. Well, you may not be able to do that if the landlord specifically prohibits you from doing that. And often they do.
Right.
Now, there is I'm going to go off a little bit here. I have to get to a different slide for 1 second here. Because there's I'm going to be adding another slide in here that has a video in it. And it's important for you to get this. It's going to explain a lot of these terms that we're learning about. Easements and water rights and such. Although easements are in the next chapter. Maybe I should put this in the next chapter. I got a great little video clip that I kind of sort of borrowed from a Netflix series on TV. I don't know if you guys are familiar at all with the Ozarks.
I used to watch them.
But I found a video in there. Well, actually, I made the video. I recorded it because it's talking about real estate and teaching real estate. When I find clips that talk about things that I think would be a good little adding to the lesson, I like to borrow those vids and put them in here. So let's see if I have that here. I already get it downloaded. No, so let me download it really quick from my YouTube channel because I know I already put it up there. And then we're going to add it to our slideshow. Because we're going to be talking about water rights in a moment. Sorry, I know you guys did not plan on this being a science class, but we're going to be learning about a little bit about some science too. Because when it comes to air rights, water rights and such, we need to understand your some science to it. Some things that naturally occur where water changes its path of flow. We're going to need to learn the scientific term for that, where the water sea levels may drop. Yes, not rise, but actually drop. And then the tide doesn't come back. There's a term for that. And we need to know that because that's going to be on exam as well. Where is this video? Please don't tell me I didn't upload it yet. All right, I think I didn't. Okay, so that's fine, whatever. I'll be adding it in, so I'll be working behind the scenes as I'm teaching the class to you. Okay, so anyway, so let's first talk about the property rights, subsurface and mineral rights. See, well, in the book, let's first highlight on page 85 at the top of the page, corporeal means tangible assets like buildings and trees, and incorporeal is intangible assets like views or rights. Or you could also add there a lease, and then put in brackets is personal property. So okay, subsurface rights or mineral rights. These could be things that are anything that's beneath the surface of the earth. It could be just the space between the surface of the earth, or it could be such things as the minerals in the ground that are below the surface of the earth. Any oil or gas or gold or silver, or you're getting my drift here, right? Those would be referred to as subsurface or mineral rights, anything that's below the surface. Air rights. Air rights are the right to use the space above the land. So the rights to use the space above the land may be sold or leased independently of the land beneath it. And such air rights can be valuable as well. This is actually its own industry, but very few people know how to sell and deal in air rights. If you're a real estate agent and you learn about the unique aspects of how do you transfer air rights, how do you value them, the legal aspects of it, you know, I think there's maybe 1 or 2 people in New York City that know how to do this. So you tell me those real estate agents are not in demand and making buco buck, right?
Oh, yeah.
This is actually something that was really uniquely used and really became its own industry when we had a developer that started doing, you know, I should start putting some of these images or a little video of this. When we had a developer that started doing this in New York, really showed that the airspace above a parcel of land can have value to it. Let me give you an example. Here, let's go to the whiteboard. Now, if you're out in the country or out in suburbia, you may have plenty of land that's available to you. So you don't need airspace. It's not as valuable because you could just get a piece of land and buy the property next door. But what happens when you're in a congested area, like in New York City, where you're limited? There's only so much land, so you have to use that land the best of you can. So what do? They build up. Can't build out, so you build up. That's when you get all them high rises, right? So you got all these properties in New York, all these buildings here in New York City, right? So you got all these properties in New York City like this. Now, years ago, there was a developer, and he went to all the neighboring properties. He built this property right here, and he went to all the neighboring properties, and he went to the owners, and this became a national story. And he asked the owners of the property if they were planning on building their buildings any higher. And they were like, no, we got our buildings, it's done, you know. He's like, well, can I buy your air rights above your building? And they were like, what? you can't build anything on top of our building. And he's like, no, I don't want to. I just want to buy the air rights above it. They're like, wait a minute. You can't build anything on top of our building, but you want to buy the rights to the air above our building? He's like, yeah. And people are like, this guy's nuts. He's either got way too much money that he doesn't know what to do with, or maybe it's because he just doesn't want us building our buildings any higher to obstruct his penthouse views. So he's either just arrogant, or he's got way too much money and he's just stupid. So this became a national story. This was like in all the magazines and newspapers way back when that happened. Now, this guy's a developer. And you think this was going to be the last building that he built? No, he was going to be building more buildings. Well, let's say he gets a permit to build another building in New York, and this is the building. They gave him a permit that he can only build that building so high. But if he owns air rights from another building here in New York, this is the way that works in New York City. Each municipality, not state, municipality, it may work different. But in New York City, it works like this. If he bought all the air rights above that building, the remaining air rights, he could transfer them to this one and then build that building that much higher. So did those air rights end up having a lot more value for him?
Oh, yeah.
Oh, yeah.
Big
Now,
money.
everybody was mocking this guy. They're like, this guy's an idiot. This guy's got way too much money. He doesn't know what to do with. Or some were like, just assuming, oh, he doesn't want to have his precious penthouse views blocked. So that's why he's doing it. He never gave a response because it's none of their business. By the way, this guy's name? He was a developer. This was Donald Trump. And he did this ages ago when he built Trump Tower in New York City. That was his first building that he built on his own. Now, did you know that back then he did not own that building? He actually negotiated with the owner. He's the developer of the building. He negotiated with the owner to put his name on the building so that he could start building a brand for himself. So however he went about negotiating it, he did not own that building back then. He didn't own it for ages afterwards. He eventually bought it and became friends with the owner he developed it for, and much later bought that building that bared his name. But before that, he did not actually own the building, which is an interesting little tidbit. But anyway, this negotiation, these air rights, the whole purpose of the story is for me to show you how valuable they could be. Let me give you another example. Now, I have something in a slideshow here, but it looks kind of like a mess when we talk about it. Oh. I don't have it open. So I have this in the slideshow here, but it looks a little bit messy. What this is here, I'm better off showing you. The yellow is one owner, the land is owned by someone else, and someone else with the green has the air rights. Okay, so I'm trying to get this color coded. Let me draw it out from scratch and I'll show you what it is that I actually have there. Let's just say that we have the surface of the earth. This is the example that they're giving in the book. They're talking about when they say air rights. Let's look at the example they give in the book. They're saying the air rights to the air above the land may be sold or leased independently of the land itself. And those air rights are increasingly important part of real estate, particularly in large cities, where air rights over railroads have been used to construct huge office buildings. And they give the example of the MetLife building, which formerly was called the Pan American building. That was an airline, Pan Am airline. It was constructed over the Grand Central Railroad station. So here's the example that I'm drawing here. You have one person that owns the land, okay? that person that owns the land, let's put his stuff in blue. He also owns a lot of storefronts on the surface of the land that he owns, okay? So this guy in blue owns the land. And then he has this real estate. Well, a lot of people think, well, that's it. If you own the land, you own the land and you own the real estate, you know, the structures that are sitting on the land. That's it. Well, no, he went and he took it a step further. This guy, he sold the subsurface rights to everything beneath the property. And that's where they have Grand Central Station there, the railroad station underneath it. And then above his property, someone else has the air rights to the structure that's the Pan American, or now MetLife building. Now, a building doesn't just float in air. So even though they have the air rights and they have this MetLife building here, well, they need to have supports, these columns that'll hold the building up, right? Because you can't just have a building floating in air. So that means that he also has to own small pieces of land to construct this building's foundational supports, right? And now the foundation supports don't just sit on the land. They got to sink them in deep, especially if it's a tall building, so it could be stable. So he also has to have the subsurface rights to these areas where the foundational supports are. You guys ever go to Grand Central Station or be in one of the trains and you see those columns all over in the subway?
Yeah.
Right? So you get these columns from these buildings like this. Maybe they got a couple of these columns that are holding up that building. So this guy owns small pieces of land, but he's got they got this big, huge office building there. So we have three different owners occupying the same space. We have in yellow over here, that's Grand Central Station. That's one owner. And that's like, what's that, the Port Authority that owns that. You have one owner in blue that owns the land above it that has buildings there, that's storefronts. And then you have somebody else in green here that owns small pieces of land where they got the foundational supports, and then they own the air rights above it so that they can construct their building. Well, all occupying the same space. You want a better look at this. Let me pull up. 1 second. I got a couple pictures of you for you guys for of Grand Central Station there. Air rights. Air rights here. So I got a couple pictures of air rights. Here's another one that's separate. It's not part of Grand Central Station. This is a different building, but here's another building in New York. You've got two separate buildings across the street from each other, but there's this structure in between them. Let me ask you a question. How did they build that? I mean, you can't just build over a city street, can you?
If you get
Using
the
air
air
rights.
rights.
Well, let's try to spitball ideas, because that's the whole reason of me bringing this up. I want you guys to start thinking outside the box. It's not just a matter of, do I own the real estate or don't I, to dictate whether I could do something or not. So how did they build this? You can't just build over a city street. Well, maybe they bought the air rights from the city that allowed them to do this, right?
Yes.
How else
Mhm.
could it have been done?
They work
Could've
something out
communicated
between the
between the
two
two owners.
Mhm.
How about maybe at one point, maybe they own this building here and this building here. Maybe they also own the land in between, which is now a city street. Maybe they dedicated that land so that a street can be built there. They built the street and then they dedicated it to the municipality, but they kept the air rights above it. Right? Just spitballing ideas out there, just so you guys can see outside the box, which we're normally thinking you either own it or you don't. How are the ways that this could be done? Maybe they bought the air rights from the city. Maybe they owned the land and they dedicated the land. And they kept the air rights and they were able to build then over the city street that way. You know, I'm just spitballing ideas out there so you guys can think in a different way a little bit. Okay. Now let me back up a bit to the beginning of this slideshow. I have a bunch of, or to the beginning of this folder here. Here is the Grand Central Station. Okay, this is like a side view of Grand Central Station. Actually, no, this is the front view. You see there's storefronts down there beneath it.
Yeah.
Okay, so you got one guy that owns the storefronts. He owns their land and the storefront. You have Grand Central Station that's sitting here as well, kind of above it, but then also below it, because they got these escalators that go down beneath the surface of the earth. So the people that actually own beneath the surface also own the Grand Central Station that's above it. And then you have this MetLife building, which is still part of that same property that sits above this. Let me give you a different cutout view of it so you guys can see this a little bit better. Okay, here's another angle of a view at daylight. Let me give you some other views. Here's a cutaway for it when the project was being discussed. So you have the Grand Central Station building. You see these are all storefronts down here. And then you have this MetLife building, which was built above it, which is hovering above the ground. They only have the air rights. This was when it was being built. The Grand Central Station was already there. They're building the building's foundational supports right here. These are the columns that hold that MetLife building up in the air. And over here, you can see those escalators that go between the buildings and the going down to the train station. So I got some historic views here for you guys. Here's another view of it, you know, Grand Central Station, and then the MetLife building is going to be sitting here above the Grand Central Station. And now here it is. Here's actually when it was called the Pan Am building. You guys remember this logo at all? Pan American, Pan Am Airlines.
Yes.
This is now the MetLife building that's sitting above Grand Central Station. This was the only building in New York City that had helicopters that could land. And the whole purpose of how they built this building above the train station was very strategic. They built it with the plan of having a landing pad for helicopters there, where people can come from the local airports, whether it's Kennedy Airport or Newark Airport. They could fly in from different areas to avoid the city traffic. You ever tried coming in from Kennedy Airport? You know,
Terrible.
So you come in, you fly in, you land on the building here. People could go down and catch the subway to get to their workplace. You know, it's a great idea. And it ran for several years until an unexpected problem came about. When you have a helicopter landing on a roof, is there a possibility that it could crash?
Yes.
So there was a crash on the roof, which put the end to that travel. There's no buildings in New York that helicopters can land on in the city because there was a crash. You see this is a huge helicopter, by the way, that holds a lot of passengers in it.
Mm-hmm.
And what happened was the landing gear broke off. It wasn't maintained as well. The landing gear broke off and the helicopter flipped over on its side and the blades flipped in, went inside the building. Some of the landing gear or helicopter parts fell to the street below. it's amazing more people were not hurt or killed. There was a couple people that were killed that were in the helicopter from the crash, and there was one person who died on the ground, a pregnant lady, where I think the landing gear fell on her, you know, and that's when they put an end to the air travel in New York City there. I don't know why I got that there. So here's that MetLife building with those escalators going up in between the buildings. Here's another cutaway of it. And here's those storefronts down at the street level. So I just want to show you guys some images instead of just giving you the drawings and showing you how valuable that space can be when you have limited space in the city. Those air rights and subsurface rights can have value to them. And we're not just talking about when you could dig gold out of the ground or minerals out of the ground. Now,
I have a question. So like, I know, so the storefronts, they own it, but in the picture, it looks like the structure is like part of Grand Central Station on the top. So like, since they own it, wouldn't they be able to like change it if they wanted to, the structure, or no?
sure, as long as it doesn't disturb those other structures too, you know, but yeah, they own the land, they own the structure, they could do any kind of modifications they want, they own it, they own that real estate. They just sold the air rights for the Grand Central Station that could be above and below it. Or in the middle of it, you know, because it looks like Grand Central Station's a lot of this stuff in the middle, and those storefronts are kind of like around the perimeter of it too, but included in the overall structure. All right, here's the water rights now that we're going to be learning about. Okay, we have littoral property rights. Littoral. Littoral begins with an L, like lakes and large bodies of water. You know what? Before we get started, this is lunch. We're just going to be getting started. I don't want to start this, and I got a lot of explanation. It's going to be at least a half an hour. So we're going to just break for lunch now. It is noon. So let me put the poll out there. Lunch until 1 p.m. And then let me put the poll out there for the morning. All right. All right. And then this will also give me time to put that video, find that video, and put that video in the slideshow for you. Okay. So us. Okay, so this was the air rights. And before we get into the water rights, I got a little video for you. It's a little goof video I got from a movie. But just to show you how, when you guys learn about these different rights, sometimes you're going to be spotting this stuff when you're seeing it in movies and in real life yourself, things that normally would just pass by you. You wouldn't even pay a second thought to it. Here's I got this as a movie clip from I guess this was a 1990s movie. Oh, this is from a 1990 movie called Balls of Fury. So let's just play this real quick. It's a little goof.
Sorry, I haven't been around in a while. And again, I'm sorry about the abbreviating your dates on the headstone. That's, the numbers are like $100 a pop, and apostrophes were free, so. Excuse me. Slide. A little close, isn't it? What are you gonna do? Because they sold the air rights to the cemetery. They sold the air to a cemetery? It's pretty okay water slide though. It's called Erie Canals. I guess it's deemed that it's haunted. Something.
Did you get that? The cemetery sold the air rights, so the next door neighbor had got a water park, and they put that water slide above the cemetery where this guy's talking to his dad. That's hard. I thought it was a funny clip though, so I figured I'd throw it in there for you guys. A little breaking up the class with a little bit of humor every now and then. All right. So anyway, let's move on to the next one. Let's talk about water rights now before we get into this now subject called water rights. So these, you will get questions about these on school exam. You will get questions about them on state exam. So this is actually a very good slide I put together as a good study guide for you. The slide itself should be your notes. You know, it puts things together a lot better than the book. Even though I'll have you highlight what you need to in the book, I try to explain things a little bit clearer and I have it all together. So when we start off learning about water rights here, let's first look, we're actually talking about not the water. Water is a precious resource and we all need it to survive. So our rights to use the water is different than what we're talking about here, which is when you own land that has water on it or bordering it, what exactly do you own and what exactly are your rights? So if you have littoral property rights, what does that mean? It means that you own land that borders lakes and large bodies of water that are affected by the tides. You know, they have high tide and low tide. If you got a small lake, it doesn't have its own tide. But I'm talking about like the Great Lakes. They have their own weather systems. They have high tide and low tide. They're affected by the tides. But the most important key element here is that those waters are navigable. So what does it mean to be navigable waters? That means that commercial shipping can go through them, like barges and freight liners and things like that. So what exactly now that we can identify when we have littoral property rights is when we own land that borders large bodies of water that are controlled by the tides and most importantly are navigable. So now that we know how to identify if you have a littoral property right, what does it make a difference? Well, the land owners only own the land up to the mean high water mark. So that means that you guys ever walk along the shoreline and you see the stain in the sand?
Yes.
Like if it's low tide, you saw where the water came up to with the stain in the sand. Well, if somebody owns a house on the beach there, they only own up to the stain in the sand there. They don't own past that. That's the mean high water mark. Mean is the average. When you don't count the outliers, like the extreme storms where the water may have come in deeper at some time. You don't count those outliers. That's not counted as part of the mean, which is the average high tide. Okay. So when you have littoral property rights, you own land that borders navigable waters controlled by the tides. So what do you own? You own the land up to the high water mark. Okay. Now, you could also have riparian property rights. What does riparian mean? Well, riparian begins with an R, like little flowing rivers and babbling brooks. Think of things like that. When you have riparian property rights, you own land that borders non-navigable waters or has those waters on your land, non-navigable waters. So you could have those non-navigable waters next to it, running across it, or just sitting on your land. The property owner can own the land, or the property owner can actually own that land that the water is sitting on top of. The water is on your land, literally. Okay, so you own the land that's underneath the water. Now, if there's two properties that are separated by a stream, the center of the stream becomes the property line between the two. Okay. I have another image that I could add to this slideshow for right here. that will show that to you. Now, you guys can see in the book, under water rights, I want you to highlight the first two sentences. Under water rights, that talks about land, that talks about littoral and riparian rights. And then you're going to turn the page. And at the top of the next page, you're going to see this. These are riparian property rights. When you have two property owners here that are side by side to each other. If the two properties, if the property line is somewhere here where the stream is, there's a property line that's separated by a stream. Well, the center of that stream automatically becomes the property line. But if that property line should move, I'm sorry, if the water should move, if that stream changes the direction in which it flows, the property line would not move. It would remain where it always had been. Okay? So, avulsion is the sudden change of the course of the stream. So it is possible for that property line to change its, I'm sorry, for that stream to change its direction of flow. Like this. So if that stream were to suddenly change its course through the process of avulsion, that property line would not turn as well. That property line would remain right where it is, because this is the sudden change. And that change may not stay. The stream could just go back. It could be only a temporary change, or the landowner could build up the land back over here so that the stream would then continue to run back in the direction that it ran. Because this is a sudden change. It's not done over time. This is a sudden change of that course of the stream. Couple of years back, we heard something in, I think it was out west, like in Colorado or something, at the top of a mountain. There's been these streams that flow down from the mountain streams. They flow down. They have these cities, these towns that were built, right? These little picturesque old towns, you know, with the water wheels, with the stream next to the stream, you know, very picturesque old town where the water suddenly changed its course because they've experienced tremendous rainfall that they normally had not had. And it caused those streams to swell and overflow and then flow down right down the middle of town instead of the way that they've always ran for hundreds of years. Now they're running down the center of town. Okay, so that's only a temporary change though. Erosion is the gradual wearing away of land by wind and water. This, you guys probably heard of this word. You know this word already, erosion. But avulsion is the new word you just learned. That's the sudden change of a course of a stream, okay? And erosion is the gradual wearing away of land by wind or water. Accretion is the opposite of erosion. Accretion is the opposite of erosion. It's the process of the water actually depositing additional solid material. That solid material could be sand, rock, dirt, soil. So that property owner's gaining additional land. It's not necessarily a positive thing. It could be happening when there are storms. Let me show you. Well, here's erosion. Here's that first word we went over, erosion. Here's actually a picture in Toms River, New Jersey, where they're putting up these fencing like this. If you ever see fences like this on the beach, there's wooden fences like this. This is actually to try to lessen or prevent when the water comes up, especially during storm seasons, from pulling away the sand from the beaches and pulling it back out into the ocean. Putting up these wooden little barricades like this will try to dig into the soil to try to lessen the effect of storms. So this is what happens sometimes in these areas that you see them putting up fencing like this to try to prevent the beaches from eroding. Now, the opposite is true. The water can sometimes deposit additional soil, like I have these images here. Look at this. The water actually deposited all this additional sand. Now, this is not necessarily a positive thing. These are pictures, I think, from Hurricane Sandy. She deposited all that additional soil. Some houses were buried in it. And you could see from the picture in the upper left how they get and deposited a couple of blocks inward, right? So that's not always necessarily a positive thing where you're gaining additional land. But I just want to give you some imagery so you guys can understand. Water does not only wear away the land, sometimes it deposits soil. Now, what do we call that solid material, the rock, wind, dirt that is deposited by the water? It's called alluvion. The process of the water depositing the solid material is accretion. The solid material that's been deposited, that sand, is alluvion. Now we could try to look up, and you've probably seen this on TV shows in the past with archaeologists pointing out to you alluvion. Let me just do a Google search really quick and see if I can find something about that alluvion. I want to find some images on it. Sometimes you see them, they get these cutaways, and you get these scientists, they're showing you at the different levels when they're trying to see in the past where something happened. They have these cutaways of the land. It could be where they're showing you the different levels of dirt. Sometimes it's like on the side of a mountain where there was where the land may have broke away or something, and you could see there's different colors in the layers of the soil. And those different colors of the layers of the soil are showing you different periods of time throughout history, different time periods. It could be over millions of years at the different layers of soil. And if you ever hear those guys talking, they're going to be throwing out these words. At this level of alluvion here is where in the past something happened, an event occurred, because you see the different color of the layer here. This is where a volcano erupted. That's the ash. That's the layer of ash. I watch these History Channel programs all the time, and you see these things. I got to get one of the videos, a list of when they're explaining those cutouts, just so that we could show it to you. Alluvion explanation. Let me see if I could find a little video or something about a scientist or somebody explaining alluvion. Let me see. I'm not going to waste the time on it right now, but either way, I did a good enough job explaining it. Alluvion is the solid material. This is what you need to know for exam. Alluvion is the solid material that was deposited through the process of accretion. So accretion is the process, and alluvion is the solid material that was deposited. Okay. Now, reliction is a permanent receding of the tides or the withdrawal of water a permanent receding of the tides where the water recedes from the land and does not come back. It gives you more usable land. But reliction could also be if you have like you have a pond or a lake on your property and the water bed dries up and now you have more usable land. Now, it's not creating any new land. That land was always there. It was just covered by water. It's just now exposing those levels of land. So, because the water dried up or the tide went down and it never came back. All we ever hear about these days because of political correctness is global warming, the polar ice caps are melting and the tides are rising. Well, some places they are, other places they're falling. The world is not round. I know, I sound like a conspiracy theorist now. The world is not round. It isn't. It's actually egg-shaped. You want me to prove it to you? You guys ever fly anywhere out of the country? Or even in the country, from one side of the country to the other? You ever notice how sometimes those airlines have your flight path, they have you going north just to come all the way back down south again, or vice versa. And it's like, why don't they just go the straight path? Isn't the shortest distance between two lines a straight line? Well, it would be if you got it flat on paper, but if you're going around a sphere that's not necessarily perfectly round, well, it may be the wider portion of the egg rather than the shorter part. This is why sometimes they have you fly over the globe in a certain way because the shortest points are that way. So, in some areas, the world is not perfectly round. It's more oval shaped, but it also has mountains which are high and valleys which are low. Water seeks the path of least resistance downwards. Now, I'll give you an example close to us here where we live. A perfect example of reliction, where the tides went out and they never came back. As a matter of fact, this happened before any of us were born. As a matter of fact, right now, we have highways. We have the Parkway, the Turnpike, Route 1, that all go through there. We have stadiums, we have an airport, all where this land once was. Look at the Meadowlands. Meadowlands all used to be underwater. But a long time ago, that water receded and the tides never came back. Today we have highways. We have shopping centers that they're building there. They have the airport, they have stadiums, right? So this is a real thing in science. If you were to believe the science, there is a such thing as reliction. So these are all your water words. You need to know them. What is the opposite of erosion?
Accretion.
Accretion.
Accretion. Erosion is the wearing away of land. Accretion is the opposite. Oh, good. Look, I even wrote that here. In the book, they don't say that. You'd have to figure it out yourself. If you go by the book's definition, you could get confused whether accretion or reliction is the opposite of erosion. But reliction is not the opposite of erosion. The land was always there. It's just being exposed now. Accretion is actually depositing solid material, building up new land that was not there before. So accretion in that regard is the opposite of erosion. All right, so let's highlight on page 86 and the second paragraph. If a stream were to suddenly change its course, it's a process known as avulsion, and the property line would not move, but would remain where it had always been. Then on the next paragraph, we're going to highlight accretion is an increase of land caused by the gradual deposit of solid material called alluvion. Then go a little bit further on that line and then continue highlighting where it says, it is the opposite of erosion. And then on the next line, we're going to highlight reliction is the, we're going to highlight that sentence. Reliction is the creation of dry land by the gradual withdrawal of water from the land by the lowering of its surface level. Now, as not to confuse you, after you highlighted that sentence, take your pen and cross out the words creation of dry land by the.
Cross out them.
Yeah, in that sentence that says reliction is the creation of dry land by the, I want you to cross out the words creation of dry land by the. Reliction is not creating any new land. It's just exposing it and making that land usable now. So this way, now you should only have highlighted, reliction is the gradual withdrawal of water from the land by the lowering of its surface level. At the end of that line, write exposing land, not creating it. A permanent receding of the tides, if you could fit it all. Otherwise, just put exposing land, not creating it. And then I added also on mine, a permanent receding of the tides, because the tide goes out and it never comes back. Now, permanent, of course, that's subjective. Permanent could be 1,000 years, could be 1,000,000 years. It's longer than I live. If I ain't gonna live that long, to me, it's permanent, right? And then the last paragraph, there's nothing to highlight there. I just put a little bracket, or you could put a little star around it. Little useful tidbit of information here about New Jersey's coastline and how much beach we have. New Jersey contains approximately 124 miles of coastline. Approximately half of that is owned by municipalities and 1/4 is under private ownership. The state and federal governments each own about 14 miles of it. And property that borders on water, rivers, lakes, or ocean is often referred to by front foot. I'm not going to get into all that. Instead, I have something that talks, I got a slide here that talks about what is a front foot, what is frontage. Actually, I created a couple slides that I already had here. It's okay. All right. So we have this slide, navigable waters, you have littoral property rights, right? What kind of water rights you have when you own land that borders navigable waters? Littoral. And you can see commercial shipping. So each property owner here only owns the land up to the high water mark, the edge of the water. Whereas if you have riparian property rights, when two properties are separated by the stream, the center of the stream would be the property line. So both properties would own up to the center of the stream. If that stream were to change course, avulsion, that's what the process is called, then the property line would not move. It would remain where it always had been. Okay. Let's see. Now, a little explanation what they're talking about right now, but before I do, I think I'll get into that video that I got from Ozarks here. Let's see. So if anybody has ever seen this, I don't know, Ozark, but
Yeah, I've watched it.
Netflix series, it's a pretty cool series here. All talking about mobsters, gangsters, drug dealers, all kinds of stuff like that. But here's where one group is looking to screw a guy out of the ownership of his property and take it from him. And they're going to use the law, the knowledge. These are gangsters on one side trying to screw up another gangster, but they're actually using the law on their side because they know the rules.
If I don't shake your hand. I'm fine, skipping pleasantries. I spent this old crew brief. The Almighty himself did not convince us to lift our blockade. What about the federal government? Who I spent the morning with? Your friends over at the power company. I want to know how it was that they were able to get your ancestors off of their land so quickly back in 1929. No mystery there. Lies, theft, intimidation. Well, they got an assist from a little thing called riparian rights. Army. Riparian rights are the laws that say who owns land under a body of water. It's kind of crazy, right? I mean, whoever stops to consider the land under a lake, or in this case, those, which last time I checked was a federal waterway. What this means, Jacob, is that the instant you flooded your land and connected it to the Missouri, you ceded that flooded land to the U.S. government. Which is how I managed to obtain a written order guaranteeing our workers access to the vote. Now, if you defy this order, we can have the U.S. Marshals escort them. And the land that you need for access roads and parking lots to get the people to your precious vote. Just the water's edge. Tell me, the feds are going to give all the surrounding land to our business partners to build shopping malls and hotels and, yes, access roads because it's in their financial interest. The tax revenue from said development is going to be massive, just like it was in 1929. They own it all. Around and below. Bad here, but I don't feel much like praying. If you try to fight this, it will cost you a lot more than a bullet in the shoulder. Which is why you asked me to be alone. You were afraid Darlene wouldn't be quite so receptive. These shorts expected to stand down. You never, ever be on my wife. Yeah. You have them? So long as you keep Darlene in line. Tell Darlene that the casino profits are going to make you richer than you ever imagined. That you can use them to buy twice the land we have now.
All right. Well, anyway, that was a nice little entertaining bit that I got from a popular show. I seen that. I was like, I got to record this. This is perfect for the class, talking about riparian rights and eminent domain. So when we get into the next chapter, I'll probably sneak this into that slideshow again there too for eminent domain, because they talk about what that is. Eminent domain is the power of the government to seize the property that's from privately owned people if it's for the greater good of the general public. Did you see how they defined it as being for the greater good of the general public? All the massive tax dollars that their project is going to produce. That's how they get it for the greater good. Right? This is how stuff really happens. And even though this is TV and it's an entertaining little way to grab your attention on it, there you go. Now, some of you are probably going to go out there and watch the Ozarks if you haven't done that before either. There you go. It's actually a really entertaining series. Definitely binge watchable. Okay. So frontage. What is frontage? The word frontage. What does that mean? Well, frontage or front feet. It's how wide the front of a lot is. That would be your frontage. Frontage is how wide the front of a lot is. Let me see. I have a slide here on my whiteboard. Let me just pull it up. I got a lot of slides on the whiteboard that I already created. Let me just pull them up here. And there's something I want to pull up and show you about frontage. What is frontage? I could show you. This one has it. All right, so you guys see the whiteboard right now in front of you?
Yep.
All right, so frontage is the width of the front of a lot. So if a lot is 50 feet by 100 feet, it has a measurement of 50 by 100, you see like this? The first number is always the width of the front of the lot, okay? And the next one would be 100. If there's only two measurements, that means it's a square or rectangular shaped lot. Otherwise, it may have a 50 by 100 by another number, or it could be 50 times IRR, like an irregular flag-shaped lot like this one. You see, looks like a flag, like you see at a used car dealership anyway. So frontage, if this lot is 50 foot wide in the front, we say that it has 50 front feet. Another way of doing this, we could say how much frontage is on the property. Now, why would that make a difference? Well, a lot of times the way zoning laws work, if you own land, are you allowed to build on it? Well, some municipalities say, well, you need to have a minimum of X amount of feet of frontage. And the whole area of the lot needs to be a minimum size, but you got to have X amount of frontage. Frontage also becomes very important when you have highway properties that is commercial property. How much frontage do you have on the highway versus the back of the highway, away from the highway? You know, that could mean you could have a lot more room there for a driveway for people to pull into the parking lot. So the frontage could be very important aspect in that regard there. Now, frontage on a waterfront property is measured on the side that, where's the front of the property on a waterfront property?
Like towards the river or stream.
Well, the water. The water is the frontage. That's why they call them waterfront properties or ocean front properties or beach front properties, right? They're giving you an indication in the name there. Because the more valuable side of the property is the side that's facing the water, right? You're not paying for the side that's facing the street, paying for the side that's facing the water. That's the more valuable side, right?
Right.
So here's an example of two lots with the frontage. Okay, no waterfront, and this one has waterfront. So you measure the waterfront based on how much of the water, how much of that property is facing the water. Because that's the more valuable side. Yeah, I gotta delete that slide right there. Sorry. Give me 1 second. I'm just looking up. Actually, I think there's another image I want to add into that slide. All right, no, that was about pictorial. Okay. Just rearranging some slides here. Sorry, give me a moment for that. Sometimes I do this in real time here as the class is going. Sorry. We could try to tweak these and make them a little better. That's all I'm trying to do. Okay, perfect. All right, we learned the term corporeal. This is once again a good slide for you guys to study from the way I got these terms up here. So not a bad notes. Corporeal, another word for tangible. These are assets you could touch and feel. Incorporeal or intangible assets are based on emotions, like the beautiful views or the rights or interests, such as stocks or leases that have value. The term chattel, we're going to highlight this on the top of 87 in the second paragraph. Second paragraph says personal property is also referred to as personalty, and all property that does not fit in the definition of real property falls into personal property. So while real estate's fixed and immovable, personal property is movable. Highlight, tangible personal property is also referred to as chattel. Sometimes it's with, sometimes it's without the S. Chattel or chattels. But what is the definition of chattel? Tangible personal property. Don't get lazy and just say it's personal property or it's tangible property. And that's wrong. You could have tangible property that's not personal. You could have personal property that's not tangible. So it's very specific. It's tangible personal property that's not attached to the real estate or it's movable. Like your clothes, your washer and dryer, the refrigerator, your bed, you know, that's all your chattel. It's your personal, tangible property. Now, it is possible to take an item, an article that is part of the real estate and make it personal property. There's a process called severance. You don't need to study this word, though. Severance, for example, you take a tree and you cut it down, severing it from the earth. It is now, that tree was once part of the land, part of the real estate, is now personal property. You can now sell it as a Christmas tree, for example, right? So through the process of severance, you could take part of the real estate and make it personal property. And the reverse is also true, but there's no fancy word like severance for it. You could go to Home Depot and buy a chandelier. Is a chandelier personal property or real estate?
Personal.
Personal.
Point, it's still in a box, it's personal property. But you take it and you attach it to the ceiling, to a chain, and you hardwire it into the electrical. It becomes a fixture. A fixture is an item that was once personal property and is now part of the real estate because of the manner that it was affixed and permanently attached to the real estate. Okay, so a fixture is an item that was once permanent, once personal property that has been attached to and made part of. Here, let me tweak those wordings. Item that was once personal property. Go to volume here. Personal property that has been attached to and permanently affixed to the real property, making it part of the real estate.
And for
But the
severance,
intention of the parties matters. When I sell my real estate, can I take the chandelier with me?
yeah,
Yeah, it was part of the agreement.
You have to make it known up front before that person ever makes an offer on that property, that chandelier is going to be taken with you. But you should also replace it with something. You can't just leave dangling electrical wires hanging from the ceiling. You know, replace it with something. That's our job, because sometimes the homeowners forget to mention, oh yeah, I want to take the chandelier with me. I'm taking that chandelier. You know how expensive that chandelier is? You know, they love that chandelier, or it's a family heirloom, or whatever the hell their excuse is. Our job is when we see things like a chandelier in a house, make sure you ask the homeowner, are you taking it with you or is that staying behind? Because sometimes they forget to bring it up that they're going to be. You should also do that when they have sconce lighting in the home. Sometimes they want to take the sconce lighting is like the old world lighting that comes out of the side of the wall. Kind of, it could like candles or something like that. It could look like it's a fancy lighting like that. I mean, when somebody's coming in, they're making an offer on the house. They're making an offer because it looks beautiful. They like that sconce lighting. They like the chandelier. And if they knew that you were taking that with them, wouldn't they adjust their price accordingly? Yes. So this is why you can't just say later, oh, I'm taking it with me. Because now it's going to become an argument that the seller's in breach of contract. They're trying to physically modify the property from what the buyer placed an offer on, and their offer was based on that chandelier and sconce lighting, etc., being included in it. So to try to avoid these types of legal issues, our job as real estate agents is when we're getting the listing, always ask, is the chandelier going with the real estate, or are you taking it with you? You know, this way it's not an issue later. Then we could put it in the listing as a note, or on the seller's property condition disclosure, we could put on there so that the buyer's aware that the chandelier or the sconce lighting is not included, or any other items that may not be so clear. Are they taking the carpeting with them? You know?
So the seller has to replace it if they take it
If they take it, they got to replace it with something.
with something else. Okay.
Yeah, you can't just leave electrical wires dangling. You'll never get the certificate of occupancy to pass the inspection to sell the house. And if you try doing that, removing it after you've had that certificate occupancy inspection, because you're trying to be crafty and slick, and I'm the agent on the other side, I may anonymously report the fact that, you know, you made some dangerous changes there, that you just left wires hanging now. You know, the city may not be so quick to give you that CO anymore because that's not how the inspector inspected it.
Okay.
Because if that house now burns down because of an electrical fire, because of that dangerous condition, you know, the city's not going to let that fly. So, all right. So what is a fixture? It's something that's once personal property that's been made to be part of the real estate. It's not always so obvious, though. I mean, chandeliers, you know, lighting fixtures, those are fixtures. The tub, the toilet's a fixture, right? What about the refrigerator? Well, we got to ask. Is it one of those refrigerators that was built into the cabinetry and it looks like it's part of the cabinetry? Well, even in that case, sometimes the owner may still want to take it with them, because never underestimate the cheapness of people. Okay. That's something I've learned, you know? So ask, open your mouth and ask. If you don't ask, it's going to become a problem later. Okay. All right. Now, trade fixtures are a little bit different. Trade fixtures are considered to be personal property. Hold on, we're getting some feedback. Let me just mute everything for a second here. So trade fixtures are considered to be personal property, but the word trade indicates business. So trade fixtures are business fixtures. They're fixtures that are used in the course of a business to conduct a business. Even though they seem like they're permanently attached, they're used for business purposes, and the tenant can remove them and take them with them as long as they remove them before the lease expires. Otherwise, it becomes a fixture and part of the real estate. Some examples of trade fixtures would be a barber's chair, or gas station pumps in a gas station, or shelving and sinks in a beauty salon, or shelving in a supermarket, or sinks in a beauty salon. You have some images here. I guess they give a couple examples here of fixtures or trade fixtures here in the page 87 with the gas pumps and things like I was talking about. Okay. Now, an emblement. All right, I'm skipping forward to one slide here because it's a little bit out of order, because I have a lot that I couldn't fit on the slide if I did add it here. Okay. Real property ownership versus personal property. The transfer of ownership of real property versus personal property. Transfer of ownership, real property versus personal property. Real property ownership is transferred by deed. Personal property is transferred by bill of sale. That's often an exam question too. Leases are considered to be personal property and intangible assets because the lease symbolizes the rights of the tenant to occupy the owner's property for a limited period of time as defined in the lease. They do not own the real property. That is why it's not considered real estate. Which is why it is not considered real estate. Okay. Now, back it up to the previous slide again so that we could go over emblements. What is an emblement? Let's highlight annual crops in the 1, 2, 3, fourth paragraph. 1, 2, 3, fourth paragraph down. Annual crops such as wheat, corn, and garden vegetables are known as emblements, and are considered to be personal property. Now, if you were to continue reading, it says one would expect a tenant farmer. Put the word tenant in quotes. Tenant farmer to be allowed to return and pick the fruits of their labor, their harvest for that season, even after a farm had been sold. Why? Well, first of all, because they don't own the farm, they're a tenant there and they're renting the land so that they could grow crops. So that's their crop. So even if a farm had been sold and that lease is not going to be renewed for that tenant farmer, that tenant farmer is allowed to pick the fruits of their labor because those crops are considered to be emblements, which are their personal property. But they can't just remove them now. They have to wait till the harvest. Okay, so that's why it's a little bit unique. But the word emblement you usually get on exams. It's what kind of property is an emblement? Personal. But is it
Personal.
annual crops? These are crops that don't grow every year on their own. You have to till the soil, plant the seeds, water them, care for them in order to get them to come back every year. All right, fixtures. We're going to write on page 88, next to the title fixtures, we're going to write part of the real estate. Fixtures are part of the real estate. Fixtures are considered to be part of the real estate. So, and then we're going to highlight the first sentence. After you write that the fixtures are part of the real estate, you're going to highlight an item or article once considered personal property, but permanently attached to the land or a building in such a manner that it has become part of the real estate is a fixture. Now, they give us a couple of legal tests for what is considered to be a fixture or personal property. But before we get to that, let's talk about tenant and trade fixtures a little bit. And we're gonna write above the word trade, write the word business. Because trade is just another word for business, right? It's a business fixture. So an article, and we're gonna highlight an article owned by a tenant and attached to rented space for use in conducting a business is a trade fixture. I'm gonna take the definition from here and I'm gonna put it on this slide as well. Yeah, it needs to be added there as well, so. All right, so we're gonna put in just another point here in this bullet list. Considered personal property, it's only used for. So trade fixtures are business fixtures used in conducting business. I'm adjusting this in real time. And are considered personal property, installed and used for business purposes by a tenant. They can be removed before the lease expires. Otherwise, it becomes a fixture, which is part of the real estate. Examples of trade fixtures would be those barber chair, gas station pumps, yada, 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 yada. All right. Somebody have their volume up really loud or something, and we're hearing the feedback in it. If you guys are getting that. Let's see, 'cause I don't have my volume up that loud and getting that feedback.
I could hear it too. It's like a whining noise in the background, right?
Yeah, that's usually when somebody got their microphone too close to the speakers, or the speaker volume is up way too high. All right. So there we go. I made that adjustment and I put it in this slide here. So the trade fixtures, I add that in, and then legal tests of a fixture, real versus personal property. So keep in mind, not all judges rule uniformly. That means the same on matters. So it's not always clear as to what is considered real or personal property, even with these tests. So the real estate agent should always ask and make clear when getting a listing what the seller is taking with them or including with the sale. Also good to note on the listing agreement or seller property condition disclosure. Okay, that looks good. All right, so keep in mind, all right, there we go. That's good. That's good, 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 good. All right, so the intention of the parties who installed them, were they intending for that to be part of the real estate and not take it with them? The method of annexation, how exactly did they attach it to the real estate? The adaptation of the article, how was it adapted to fit? And the relationship of the parties in the thing. But even when you have the answers to all these, it's still not that clear. I've sold properties where then you have, or was dealing with the buyer's end, where you had the seller who was trying to hold the remote control for the garage door opener, and they wanted $35 for each additional garage door opener. Or they wanted to charge the buyer for the house keys. No, the house keys are a fixture. They go to the front door. They're part of the front door lock mechanism, which is part of the real estate. That's not personal property. The keys are part of the real estate. They go with the real estate. Even though we always advise the buyer to get the key, to get the locks rekeyed. You don't have to change the locks. Sometimes we say, just make sure you change your locks, even though you got the keys, because we don't know where the keys are floating around on this property. Well, you don't have to change the locks. You could save a lot of money if those locks are in good condition by having a locksmith come out and just rekey the locks that are there so that a new key would be required to open them. You know they could do that? Well, if not, now you do. And I always suggest to people to do a final walkthrough of the property before closing. On your way to closing. So walking through the house for inspections, which can be done several times. When looking for a home, showings are a form of walkthrough. We get appraisals are walkthroughs of the sort. Home inspections are walkthroughs. A home inspection after repair follow-up is always suggested, because when we do the home inspection, we find something that we want the seller to fix. We should always do a follow-up with the home inspector again to make sure that the work was done and it was done properly. Don't wait until the final walkthrough before closing to find out that they didn't do the job, they didn't do the work they were supposed to, or they didn't do it right. That could put delays in the closing, or the buyer's just going to be like, oh, screw it and go through with the closing, but then they're going to get a house with the repairs not done that the seller should have gotten done. And that's just wrong. For the municipal inspections, for the fire and certificate of occupancy before we could transfer the ownership. And then lastly, the final walkthrough, which I suggest be done on the day of closing on the way to the closing table. That's when you should do the final walkthrough. Most agents will schedule these final walkthroughs once the seller moved all their stuff out, which could be days in advance before the closing. Now, what is the purpose of the final walkthrough? It's to make sure that here, let me actually put that on this slide. Let me make a little adjustment to this slide here of what that purpose of that final walkthrough is.
It's not the damage to the house done.
Yeah, it should be done on the day of closing, on the way to the closing. The purpose is to ensure the seller is leaving the property in broom clean condition. That means that they didn't leave any garbage behind. They didn't leave any furniture or garbage behind, and didn't do any damage when moving their stuff out.
I got a question.
Yeah.
What if once you buy the house, you look in the attic or some compartment and you find money? Is that yours now, or do you have to give it back to the whoever was the previous owner?
It's your house. It's yours now. All right, so let me see. I have to resize this a little bit so everything fits here. Okay, so for final walkthrough, I updated this definition. I said the purpose is to ensure the seller is leaving the property in broom clean condition. They didn't leave any furniture or garbage behind and didn't do any damage when moving their belongings out or remove anything they weren't supposed to, like the chandelier, the kitchen sink, or the toilet. All right. The kitchen sink, is it part of the real estate?
Yes.
So what do we call that? It's a fixture,
Fixture.
right? Chandelier, that sometimes may or may not go, depending on if they said they were going to take it or not. What about the toilet, your toilet bowl? Is that a fixture?
Yes, a fixture.
Would you take it with you when you left?
No.
No.
Now, I had one girl in class one time. I was talking about all these things that are part of the real estate. That they're fixtures. They're part of the real estate. You wouldn't take it with you. And I mentioned the toilet, and I was like, the toilet, is that personal property or fixture? And then everybody was like, oh, it's a fixture. I was like, yeah. Well, to clarify this, would you take it with you when you left or not? Or is it part of the real estate? And they're like, oh no, toilet stays, you know? And I had one girl in class and she was like, no, when I move, I'm taking my toilet with me. And everybody in class shot her a look like, what the hell? You know, that's like the weirdest thing. But she had a very valid reason. And I would have never thought of it. She followed up by saying, listen, she's like, I'm a tall lady and my husband's even taller than me. She's like, you know how hard it is to sit on you little people toilets? It's like a kid sitting on a little play toilet, you know? She's like, you know how hard it is to find these toilets? They're taller toilet seats that we have. And I was like, you know what? You make a legitimate argument. But if you did not notify the buyer that you were taking those toilets with you, maybe the buyer's taller too. And maybe they like that. So this is why you need to specify this at the time you're getting the listing, that you're going to be taking the toilets with you, maybe, but you can't just leave those sewer pipes exposed. You got to replace them with something else. So make a comment there that you're going to be taking those toilets with you and you're going to be replacing them with another, maybe American Standard or some other type of toilet. Okay. Make sure that that's spelled out.
And you have to replace the toilet, right? You like a owner can't say I'm just taking them and leaving them, right?
No, because if you take the, oh, you mean if they say they're taking it and then they don't take it?
No, I'm saying like if they take their toilets, they have to replace them for the
Yes.
new homeowners, right? They can't
Yes.
just take them and leave them, right?
Yeah, because that's a danger. If you remove the toilets and you leave the sewer pipe exposed, sewer gases can come into the house and they could be deadly. They could also be explosive. Now, your sink in your kitchen, your sink in the bathroom, in your tub, the way that the plumbing is run, we have these P-traps underneath them, what we call a P-trap or an S-trap. Let me get a slide open here. I could show you really quick what I'm talking about. Here's a blank slide. You guys see the whiteboard? So let's just say in your sink in your house, you got a sink in your kitchen, or that's your sink tub or whatever. You have the pipe that comes under, if it just went straight out the sewer, versus if you have a sink tub or whatever, and you have a pipe that the plumbing code requires the pipe be bent like this. Now, why is that? Well, the purpose is because it creates a little lock. Let me try to do this in 3D. Okay, so here's your pipe. Okay, that's your pipe. And what happens is the water won't always drain out. You'll always have water filling the pipe up here. So this way it would prevent any sewer gases from coming up and into the house. They'd be stopped by the water. The water acts like a trap that would prevent the gases from coming in. See, if you just have a sewer pipe like this, those gases can just come up straight through the pipe and into your house. And those gases, they could be deadly. The gases could also be explosive, you know, and your house will stink. So if they're going to remove the toilet now, the toilet actually has this S-trap built into the toilet.
Yeah.
So the floor in your bathroom has a little gasket over here that the toilet sits on, and the pipe goes straight down. There's no trap. There's no trap like that built into it. It just goes straight down because the toilet bowl itself, which sits on here, if you ever look at you could probably even see it built into your toilet. You have this like thing like that built into the shape. You could even see it if you look at the side of your toilet, that there's a shape, it's some kind of a P or a S shape.
Yeah.
And that catches the water just like this would, so that it creates that lock, that vapor barrier, that those gases can't come into the house.
Thank you. I was curious about that. Why is it always S-shaped? Because when I'm cleaning it, I can feel it. Okay, that makes sense.
That's the code. That's the plumbing code, the builder's code. that they need to do this. Now, building codes dictate, it used to be that you could just do this, but that's dangerous. So, they built, as we started making all kinds of safety, building codes are for safety reasons and all kinds of other reasons. So this is actually a code that requires it be like that. Okay. All right, once again, another chapter that has this in here. Title. What is title? Just a word that means ownership, right? Deed is a document to transfer one's ownership, right, or interest in real property. In this chapter, we spoke about air rights. We talk about mineral rights. Can you sell the property or sell your rights independent of the property of the land?
Yeah.
Yes,
Yeah.
you can. But how do you transfer those rights? By some sort of deed of conveyance. That's why I have written here, a deed is also used to transfer a deed is also used to transfer one's rights, title, or interest in real property, like air rights, mineral rights, subsurface rights, okay? Or a partial ownership interest, which we also discussed. And a deed is the proof of ownership? No. What are the 4 proofs or evidences of title? Abstract of title with attorney's opinion, a certificate of title, title insurance policy, and a torrent certificate. When does the transfer of ownership take place?
I'm sorry, I didn't hear that.
Delivery and acceptance of the deed itself. This is why deeds do not need to be dated or signed by the buyer. Because when does the transfer of ownership take place? Upon delivery and acceptance of the deed itself. And that ends this chapter.
I have a question. What if, say, you have a house, right? And someone gives you the house, but the house doesn't have the air rights with it.
Okay.
So if you wanted to buy the air rights with it, will it say on the deed, okay, this is who now owns the air rights, or you're gonna have to personally on your
No.
end
Yeah, it'll
transfer?
say that your rights are limited, but it'll say who has those rights.
Okay.
Okay.
All right.
Well, but that would have to be updated, because can that person sell their air rights to someone else?
I guess so. I'm not sure.
Well, how would we know?
The deed would say what rights the
Well,
person.
the deed would specify what rights you have, but would it say who currently owns them?
No, but it'll have like,
It'll say who currently owned them at the time you bought it. But today, they may have sold those air rights to someone else, and that person may have died, and then somebody else inherited those air rights from them. And, the only true way to find out is if they recorded it in a public record, you could see who holds those air rights.
okay.
Okay. So let's do the key terms to review for this chapter 5. There are 2 key terms to review. Let's do them. All right. Belong to the owner of the land below. If the land is below, what's above? I'll give you guys a tip. Belongs to the owner of the land below.
Air rights?
Air rights. If the land is below, what's above? The air, right? So choose A.
I was stumped by that for some reason.
They ask things in weird ways like that. That's why I tell you, ask yourself a question about the question. Belong to the owner of the land below. If the land is below, what's above? See how I
Yeah.
asked that question? The air. Boom. And then the answer becomes, oh, duh, But, so something weirdly worded like this. And listen, they do it on state exam. They even do some of that on the school exam. So if something's weirdly worded like that, just ask yourself a question about the question, and usually you're reframing it in a way that you're like, duh, That's should have thought of that, right?
Yeah.
The wearing of the way of the land, usually due to the actions of the wind and water.
Erosion.
Erosion. 10 is B. Leave real estate to someone by will. What do we call it when we leave real estate to someone by will?
Not hereditament.
Device.
Devise. 8 is
Ah.
D. Now you mentioned hereditament. Now hereditament, we actually skipped over it because we never see it on exams. You actually will see it on exams as probably a wrong answer option, but on page 87, it says everything that can be owned may be classified as either real or personal property, and anything that can be inherited is a hereditament. So
Okay.
hereditament sounds like inherit, you know,
Mhm.
anything that can be inherited is a hereditament. All right. But you probably have that question on exam, but I know it's on a school exam as a wrong answer option on a question. Anyway, tangible.
Shadows?
Corporeal, yes, somebody said it. 7 is D.
Shadows.
Tangible is corporeal. Another word for tangible is corporeal. Something you could touch or feel, right? 7 is D. Annual crops like wheat, corn, or garden vegetables. Emblements. 9 is E. Tangible personal property.
Shadows.
Cattle. 6 is F. Manufactured attachments to land.
Picture.
Look for something else. What do you
Improvement.
call a manufactured attachment to land?
Improvement.
It's an improvement when you attach it. All right.
Yeah.
13 is G. Once personal property, now real estate.
That's fixture.
That would fit a little bit better in that. Yes. So 11 is H, fixture. Sudden change of the course of a stream.
Accretion. Avulsion. I'm sorry.
Avulsion. 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 By the way, let me give you a tip really quick right now. Let me open up that slideshow and go back there real quick. I want to show you something. Class notes, PowerPoint. I want to show you guys, because if you see these words side by side on exam, if you see these words side by side on exam, avulsion, alluvian, you know, all these words that begin with A, you got A-L-I-O-N's in them. They all look the same after a while if they're all lined up next to each other. Here, let me put this up on the screen for you. Look at this, avulsion, alluvian. Imagine they're side by side as exam answer options. They both got A's, V's, U, L's, I's, O's, N's in them, right?
Yeah.
The only difference is avulsion has an S in it. S for like sudden change of a course of a stream. Accretion, I'm sorry, alluvian. What is alluvian? It's that solid material that you've gained. How do you remember alluvian? Look, I have it written in here. Alluvian has 2 L's. You gain an L, you gain some dirt. So the one that has 2 L's is the one where it's the dirt that you have gained. That's the way I remember it. The one with 2 L's. The one with 2 L's, it's the one you gain an L, you gain some dirt. Right? That's the way I remember it. Sorry, I did not go over that earlier. I should have explained that a little bit better there. All right. So which letter are we on here?
J.
J.
Okay, anything that can be inherited. Oh,
Herediment.
that's a herediment. So 12 is J. Yeah, but we didn't actually do, 12 is J. An increase of land caused by the gradual depositing of solid material by the actions of the water.
Alluvian.
Accretion.
Is that alluvian?
No, hold on. An increase of land caused by the gradual depositing of solid material by the actions of the water. They're looking for the actions. What is
Accretion.
the action of the
Accretion.
water? Okay,
Ah.
accretion, one is K. Okay, so they're looking for the actions. The solid material that's deposited is one thing, but the action is accretion. One is K. Possession, control, enjoyment, and so on. These are all examples of
Bundle of rights.
your bundle of rights. 5 is L. And what do we call the solid material deposited by a body of water through the process of accretion?
Alluvian.
Volition.
Alluvian.
Alluvian.
Alluvian. You gain an L, you gain some dirt. Alluvian. 3 is M. All right. All right, key terms 2. All right, so next to letter A, I want you to cross out the words creation of dry land by. Or just cross out creation of dry land. And then you're going to write above it, permanent receding of the tides. Permanent receding of the tides. receding, permanent receding of the tides. So, a permanent receding of the tides by the gradual withdrawal of water. 9 is A, reliction. Correct. Everything that is not real property could be classified as?
Personal property.
6 is B, personal property. Very good. Or personal property or personalty. Specific tract of land with I'm going to add to that. Specific tract of land with legally defined boundaries. What do we call that?
Parcel.
A parcel. 5 is C. Subsurface rights are also referred to as?
Mineral rights.
4 is D. Removable by tenants.
Trade fixtures.
Trade fixtures. 12 is E. Trade fixtures. Land improvements and bundle of rights.
Real estate.
7 is F. Use of water by adjoining landowner.
Riparian rights.
10 is G, riparian rights. 10 is G, riparian rights. Adjoining landowner. Remember, if you have the land or the water in between an adjoining property, but they're separated by the water, the use of that water, that's riparian rights that they have. Intangible, another word for intangible.
Incorporeal.
Incorporeal, 1 is H. The earth, including the air above. Land, 2 is I. Yeah, if the air is above, what's below? All right. So 2 is I. All right, synonym for real estate. It's now in English
Real
class.
property.
Real property or realty. 8 is J. Ownership of minerals, oil, and so on.
Subsurface rights.
11 is K. And land bordering bodies of water affected by the tides.
Littoral rights.
Littoral rights, 3 is L. That is correct. All right. And now we'll get into chapter 6. We open up the slideshow. Chapter 6, Estates and Interests in Land. In this chapter, you're going to be able to identify all the characteristics of real estate and land, describe the characteristics of encumbrances such as liens, easements, and encroachments. We're going to learn about those words. And we're going to start off with estate and land. To understand this, let's go by my definition. What is an estate and land? It describes the amount and kind of interest that a person has in real property. So we're going to highlight that sentence above the numbered list here. The amount and kind of, it says ownership interest, but we're going to cross out the word ownership. They're saying ownership interest because this particular chapter is only talking about the types of the category of ownership. So to be more accurate in the definition for your studying of what an estate and land is, let's highlight the amount and kind of interest that a person has in real property is an estate and land. And now there's two categories of estates and land, which they have in the numbered list here. We have a freehold estate, highlight freehold estates, and then right after it, ownership category, 3 types. There are 3 types of freehold estates. Freehold estate is the category of ownership, and there's 3 types of freehold estates, which we're going to learn about in this chapter. And then the other category is less than freehold, which is a leasehold estate. Highlight leasehold estates, and then write 4 types. Chapter 12, page 196, 197. We're writing that in the book there. Next to leasehold estates. 4 types. There's 4 types of leasehold estates. And those are gone over in chapter 12, page 196 and 197. Just giving you a cross-reference. Don't worry, I have them in the slideshow here just to briefly explain them so your notes are all together for studying all the different types of estates and land, even though we're not going to go into them in any depth. All right, not right now in this chapter. So here are the 3 types of freehold estates that describe ownership. They are fee simple, fee determinable, and a life estate. Fee simple, fee determinable, and a life estate. So on the page, top of page 94, highlight the first 2 words there, freehold estates, and write the number 3 in front of it. 3 freehold estates. And here's the list of the 3 types of freehold estates, which you could highlight. Fee simple, fee determinable, life estate. Don't worry, we're going to go over and I'm going to explain what they are just after we go over this. The next paragraph, I want you to highlight leasehold estates involve tenants and are estates for a period of time. Leaseholds are considered to be personal property, not real property. And what kind of asset are they? Intangible. So right underneath that, an intangible asset. An intangible asset. Now, this isn't here in the book because leasehold estates are discussed in chapter 12 on page 196 and 197. But I'm going over them here in this slideshow really quick just to give you the breakdown. So leases involve tenants who are lessees, who are not the owners. The owners are the lessors. A lease is considered personal property, which is an intangible asset, not considered real property ownership. A lease only describes the tenant's rights to occupy someone else's property for a limited period of time as defined in the lease, as well as the terms, the length of time, what's being leased, and any limitations. And there are 4 types of leasehold estates that we're going to learn in chapter 12. They are estate for years, periodic estate, a tenancy at will, and tenancy at sufferance. And we're going to go over them in depth in chapter 12, but not right now. Ooh, little action there, little slideshow. So fee simple, what is that? Fee, it goes by three names. Fee simple goes by three names. It could be called fee simple, or fee simple absolute. All three terms mean the same thing. It's the fee simple category. It's the highest form of ownership in real estate recognized by law. It's the most complete form of ownership. It is ownership forever without restrictions. And I want you to write that right next to fee simple estate. I want you to write that above that. Ownership forever without restrictions. It's the most complete or the highest form of ownership recognized by law. It's ownership forever without restrictions. So just write that next to the title of fee simple estate. Ownership forever without restrictions. And once you have that, I want you to highlight fee simple is the highest type of interest in real estate recognized by law. And on the last line of the same paragraph, we're going to highlight fee simple, and fee simple absolute are used interchangeably. All three of those terms describe the same thing. That's what that means. The first category of estate. Fee simple absolute, it's all the same thing. It's the unrestricted ownership forever. Next, we have a fee determinable estate. Also goes by the names defeasible or conditional fee estate. This is ownership forever, but that ownership is based on a restriction. Those restrictions are called restrictive covenants, and they can only be added by private parties, not by governments. The government has their own restrictions of what they could allow us to do on our own property. If I'm selling you a property and I want to put a restriction on how you could use that property, I'm going to write it in the deed that's conveying the ownership to you. And that's going to be referred to as a restrictive covenant. What is a covenant? The word covenant, it does not mean a bunch of witches. That's a coven. All right. A covenant is a legal promise. So a restrictive covenant is a restrictive legal promise. Right? So if I place a restriction in the deed, if the restriction is violated, ownership would revert back to the person who placed the restriction in the deed. And this would be referred to as the possibility of reverter. It's possible that if you violate the restriction terms that you agreed to, that the ownership would revert back to the owner who put that restriction into the deed. Now, the restrictive condition runs with the land. That's a term we need to understand as well. Running with the land, that means it just passes on to, from one owner to the next. Okay, so this restriction passes on from one owner to the next and can only be removed by the person who added the restriction to the deed, or their heirs who inherit their rights. So basically, if that person died, well, you'd have to then try to get their heirs to remove the restriction, or by a court, although courts don't like to mess with people's wishes. Now, there's also another term here called a remainder man, who's a third party named in an instrument. Instrument's a fancy word for document, to be a beneficiary. So here, let me spell this out so you guys understand. If I own a property that I'm selling to you and I'm going to place a restriction in the deed, as long as you don't violate that restriction, you're the owner of that property forever. If you violate that restriction, there's the possibility that the property can revert back to me. Now, let's just say I don't want the property back. Instead, I'm going to name my neighbor to be the remainder man, that in the event you violate the terms, the restriction that I placed in the deed, the neighbor will become the owner. So I'm going to name the neighbor to be a remainder man. So you think they're going to keep a close eye on you, make sure you're not violating those restrictions in the deed, knowing that if you do, they could become the owner?
Of course.
Yeah, absolutely.
Absolutely.
So I just gave you an example where you could find, so you could understand and get a picture of who or what a remainder man is. So we went over a lot in that second one. Fee determinable, also known as defeasible or conditional fee estate. Let's highlight. Fee determinable, also known as conditional or defeasible fee, is an estate in land that can terminate on the occurrence or non-occurrence of a specified event. I think I told you about a story about these guys on 1015 radio station who were asking their audience around the Christmas holiday season, if anybody knows of any holiday lighting shows where people light up their houses and they do these crazy displays. And I gave you an example where somebody, the guy who built all the houses on this one block, put a restriction in the deed that says that at a certain date, they had to put up a holiday lighting display, and by a certain date, they had to take it down. So this is what they mean by on the occurrence or non-occurrence of a specified event. I could be a Scrooge and put in a deed that you can't put up a holiday lighting display. Right? Or I could say, no alcohol can ever be present or consumed on these premises. It's kind of a wacky restriction, but there's nothing illegal about it. If I put that restriction in a deed and you buy the property knowing that restriction is there, that means you took on that obligation fully knowing. And you may be fine with that because you don't drink. You think that's going to affect the value when you go to sell the house, the value or desirability of the property when you go to sell it?
It might, yeah, for a lot of drinkers.
If you tell anybody who's buying the house, hey, guess what? You can't drink ever. Can't have any alcoholic beverage ever in that house. Not even on the holidays. Not even for graduation or a wedding.
I'd mess that one up.
Right? So, yeah, I would say that would affect the value and saleability and desirability of that property a bit. So keep that in mind. All right. So I want you to write next to the title, fee determinable. I want you to write next to the title, ownership forever, but based on a restriction called a restrictive covenant. So this way you don't have to just necessarily resort back to my slideshow. If you didn't print it out, you could actually just study it from the book. So you're gonna write next to the title, fee determinable. You're gonna write next to the title, ownership forever, but based on a restriction called a restrictive covenant. So just, you're going to be writing everything I have on this line here. Ownership forever, but based on a restriction called a restrictive covenant. See that? Everything on this line, you're writing next to the title. Ownership forever, but based on a restriction called a restrictive covenant. Ownership forever, but based on a restriction called a restrictive covenant. Everybody get that down? Now I want you to highlight on the last line, remainder man is a third party named in an instrument. And right at the end of that line, to be a beneficiary. To be a beneficiary. Does anybody have any questions for me? Does everybody understand these two so far?
Mm-hmm.
Yeah.
Okay. Next, we have something called a life estate. A life estate is ownership based on the life of the person it is given to. So I want you to write next to the title, life estate, is ownership based on life of person it's given to. Is ownership based on life of the person it is given to? Is ownership based on the life of the person it's given to? So that person cannot leave the property by will to their heirs, even though if you have a life estate, you own that property, but you cannot leave it to anybody in your will because it's based on your life. And when you die, so does the ownership of that property. That property ownership will revert back to the person who gave you the life estate, or a remainder man if they named somebody else to get the property after you die, or their heirs. So if you have a life estate, you do own real estate and you have all the rights of ownership. You could lease the property, you could sell it, you could give it away. You just cannot destroy its value. You have to maintain the property. You have to pay the taxes on the property. It's your property. On the owner's death, the ownership would revert back to the person who gave the life estate, or to a remainder man, or to the heirs, or to the heirs of the person who was supposed to get it back, or to a remainder man, or their heirs. All right, so I gotta go through this because I made a little modification. All right, now, there's a little twist to the life estate agreement here. I got this in the wrong spot. All right. So you guys understand what a life estate is? If I give you a life estate, I'm giving you ownership of my real property. You could do anything you want with it. You could lease it, you could sell it, you could give it away. I'm not sure exactly how you would value a life estate, but if I give you a life estate, are you the owner of the property?
Yes.
Yes.
So if you wanted to, you could lease that property and collect rents on it. It's your property. You have all the ownership rights of any owner. It's just that when you die, you cannot leave that property in a will to somebody because those ownership rights will come back to me. I'm the one.
What if you're dead?
What's that?
What if you're dead?
Well, then who gets my assets or my rights or interest when I die?
If you willed it, you're
my heirs or whoever I name in a will.
Okay. Okay.
Right.
But I can't will it to anybody else once I die, even though I own it. Okay. Understood.
Yeah. Because, yep, exactly. Now there's a little bit of a twist to this. We're not done yet. We have something called a life estate per autre vie. Per autre vie means for the life of another. It is not French, it is Latin. If it was French, it would be P-O-R, okay? Per autre vie It means for the life of another or based on another's life. So a life estate per autre vie is not based on your life. It's based on someone else's. And an example of a famous life estate per autre vie was Hugh Hefner. You guys remember Hugh Hefner? He owned the Playboy Mansion, the Playboy magazine.
Yes.
Yeah.
Everybody heard of Hugh Hefner, right? Well, I have
Yes.
a link here. I'm going to open up
Yeah.
this link real quick. I want to show you. Okay. Do. Here's something when it opens up. All right, so the Playboy Mansion, it was owned by Hugh Hefner. They put a little funny thing, for sale with owner. What Hugh Hefner did is he sold the Playboy Mansion with a stipulation that whoever bought it from him has to give him back a life estate. What do you mean they give him back a life estate? Means that if they own that property, they bought that property from him, they have to give him ownership and allow him to live there for the rest of his life. He said, I'm selling the property so I could get the money now, but I'm not moving out. That's what they mean, for sale with owner. I'm going to sell you the property with a stipulation that you have to give me a life estate back so that I could live there for the rest of my life. I don't want to move from this estate. So it's not based on the life of the person it's given to. It could be based on a third party as well. Actually, in this case, the life estate is not per autre vie with Hugh Hefner. So I think I had my slideshow right to begin with. Dang it. That's just a regular life estate. There we go. All right, so the Hugh Hefner is a regular life estate because he's the one that was getting the life estate back. An example of a life estate per autre vie would be if, let's just say that I have an aging parent. I have my mother. She's a disabled, aging parent, and I'm going to give you a life estate for my property because you have, you're a good friend. You got some nursing experience, whatever. I'm going to give you a life estate based on my mother's life, that you're going to be the owner of the property. I'm going to put a couple of other stipulations in there too, because if I just say you have a life estate based on my mother's life, you could still put her in a nursing home and then rent out the house and collect rent. So I'm going to put some further stipulations in there that I'm going to give you a life estate for my property based on my mother's life. So I'm giving you a life estate per autre vie based on my mother's life. As long with this further stipulation, as long as you both live in that house and you're taking care of her. She has to be living in the house. So you could see an example where this would make sense to have a life estate per autre vie. So I'm giving you the complete ownership of my property. All you got to do is take care of my mom. All right. Now, when she dies, what happens to the property? It comes back, it reverts back to me or my heirs or a remainder man if I want to name somebody else to get it. So I might not have told you about that, but I could have put in there remainder man. I could have named the remainder man. That remainder man would be you. Let's see. But either way, let's see. So what does per otra vi mean?
For the life of another.
For a life of another, for another's life, right? A life estate is ownership, and it's based on the life of the person it is given to. A life estate per otra vi is not based on the person of the life it's given to, it's based on someone else's life, a third party's life. So, per otra vi, for the life of another, based on another's life, it is given, it is not based on the life of the person it is given to. It's based on a third party's life.
You're not showing the slides right now, by the way.
No, what are you seeing? Oh, you're still seeing it? Okay, that's all right.
Yeah.
I'm updating the slide anyway, so you're probably gonna see something blank on screen anyhow, so just wait a second. So a life estate per otra vi is not based on your life, but someone else's, a third party. Okay. So, there we go. So I just made this adjustment. Per otra vi, for the life of another, based on another's life. It's not, it is not based on the life of the person it is given to. It's based on a third party's life. Okay. Why is that staying there? Based on a third party's life. I don't know why it's saying third party life there. It's not attached to my slide. Something with that third 3RD there. It's kind of a problem. Whatever. Whatever, fix that later. All right, next, so fee simple. Just do a recap. Fee simple, also known as fee simple absolutes, the highest form of ownership recognized by law. It's unrestricted ownership forever. Holders entitled to all the rights in the property. On the owner's death, the estate passes to their heirs. They could decide what happens to their property when they die, who gets their property when they die. This is known as fee simple, or fee simple absolute. Fee determinable in New Jersey, an estate that can terminate on the occurrence or non-occurrence of a specified event, a restriction. That restriction is called, anybody?
Restrictive covenant.
Restrictive covenant. Restrictive covenant. Okay, so fee determinable, also known as a defeasible or conditional fee estate, is ownership forever, but based on a restriction. If the restriction is violated, ownership reverts back to the person who placed the restriction in the deed. This is called the possibility of reverter, or it would go to a remainder man. That's a third party named in an instrument or document to be a beneficiary. That restrictive condition runs with the land, passes on to the next owner. It can only be removed by the person who added the restriction, their heirs, or court. A life estate is limited to the life of the person it's given to. Ownership reverts back to the person who placed or granted that life estate, or their heirs, or a remainder man when the person they give it to dies. Life estate can be tied to the life of a third party called a life estate per autre vie. The holder of a life estate has true ownership of real property with all the rights and benefits, but only for their lifetime. Life interest may be sold, leased, mortgaged, given away. All right, if I buy a life estate from you, what am I getting?
You're getting the property based on your lifetime, no?
No, based on yours.
Oh, based on my life, yeah.
Yeah.
Okay.
So if I'm giving you a life estate, I'm giving you a life estate based on your life. When you die, what happens to the property?
Goes back
It
to
goes
you.
to-
Comes back to me. There you go. That's it. Just that simple. So you can't leave it in a will then, right?
No.
All right, important to know. All right, now we're going to learn about. Well, did we highlight the first sentence under life estate?
Yeah.
Okay.
Yeah.
And then on the next page, 95, on the second line, at the end of the line, we're going to highlight a life estate per autre vie for another's life. Then on the next paragraph, we're going to highlight the holder of a life estate has true ownership of real property. And go down to the last line in that same paragraph and highlight, but it always ends on the death of the person against whose life it is measured. Now, I already explained this to you, dower and courtesy, when we went to chapter 20 earlier, but we're getting to it now. So let me just go over it again, do a little quick recap again.
Okay.
Dower and courtesy are ancient rights that a spouse has in their partner's property. Dower is the wife's interest in her husband's estate upon his death. Courtesy is the husband's interest in the wife's estate upon her death. New Jersey abolished the creation of any new dower or courtesy rights as of May 28, 1980. That means that they didn't abolish all dower and courtesy rights. They just abolished the creation of any new ones. So anybody who was married before May 28, 1980 still has dower and courtesy rights in New Jersey. That means your spouse has rights to all the property that you own during your life. Now, if you're married after May 28, 1980, they instead now just give both the husband and wife what we call the right of joint possession of their property that is their main marital residence. Your spouse only has a right of interest in your main marital residence, but not any other property that you may own. Any comments on that?
I think I remember you saying like to remember, just remember Dow, like a female deer.
Yeah. To remember the difference between dower or courtesy rights. Dower begins with a doe, and a doe is a deer, a female deer. So dower is the wife's right, and because men are courteous to women, courtesy is the man's right. That's the way I remember whose right is whose, because you'll get questions on exam, which one is the wife's right, which one is the husband's right upon their death, you know?
Mhm.
But that's not really what I was fishing for. But thank you for bringing that up again to explain it in this recording. The what I was fishing for is a lot of times when I say this, that if you were married after May 28th, 1980, your spouse only has an interest in your main marital residence, but not any other properties that you own. Sometimes I get bitter people who have been divorced, and I usually don't have to say anything. They'll just spurt out, "That's bullshit. She got half of everything." And when they say that, you know why I say, no, that's correct. And they'll sit there and they'll argue with me, well, then why did she get half of everything? And my response will be, she had a good lawyer. And I'm not just being flippant about it. What do I mean she had a good lawyer? Well, if the lawyer could link $1 of the marital assets to maintain that separate property that you own, then your spouse can claim ownership rights to it as well. They have a financial interest in it because you use money from the joint bank account to maintain it. The only way that you could truly own real estate and be married and have a separate investment property that your spouse doesn't have any interest, you got to keep the financials separate. Or here's another way to do it. You ready? Get a prenuptial agreement. You get a prenup. You know who needs a prenup? Don't just say married people.
Rich people.
The opposite.
Poor people.
You think that if a rich person is going to get divorced, they really give a crap about giving you $1 million to get the hell out of their life? Here's $1 million. Get the hell out of my life.
Never thought about it that way.
But when you have other people like you and I, you know, that aren't rich. Look, when I used to be married, I'm divorced. And when I was getting divorced, I was shopping around divorce attorneys. They're expensive. Cheapest divorce attorney I found was about $325, $350 an hour. An hour. Minimum billable time, a half hour. Right. So they got to send a fax, and I gotta, what is that, $150? You know, 150 or more dollars for them to send a fax. All right. Who's getting rich in that? Only the attorneys are. Right. And by the end of the day, when they battle it out of who gets what, the attorneys got all the money. Neither spouse ended up with anything. Right. So it is even more important for you, if you're not rich, to have a prenuptial agreement. It's basically a prenuptial agreement is an agreement in advance as to, listen, if our marriage doesn't work, I hope we work. I love you to death, and I hope we stay together for the rest of our lives. But in the event that something happens and that we don't stay together. Now, a prenuptial agreement would be a lot of what if scenarios run into it. We just grow apart. Who gets what from what we came into the marriage with? And what if we started a business? Or what if we hit the lottery? Or what if we had a kid? And what scenarios would dictate who gets what and how much? You could spell that out in advance. So now if you go to get divorced, you don't got to worry about it. We had something all written up in advance about an agreement about what was going to happen. What happens in the event that one spouse cheated? You know, who gets what and how much? So that you're not on the hook for the rest of your lives, you know? I mean, New Jersey's got some horrible laws when it comes to divorces that do not favor men at all. You get some women out there that say, yeah, guys get the raw end of the deal there, you know, with it, because you get some people who are having to pay alimony for the rest of their lives to their spouses, you know, and it's usually the guy paying the woman, not the other way around, although it could happen. It could happen. But that's not usually the case. Now, New Jersey tried to put some patch them, fix them up or to that, the policies in New Jersey, but it's still screwed up. It's still rough. So it's a good idea that if you live in New Jersey, you're getting married, you get a prenup. Okay. Especially if you're not rich. Because if you're rich, it ain't no thing to say, here's $1 million, get the hell out of my life. You know, what's $1 million when you're worth $1 billion, you know? All right. The property acquired before this date. So I just give you the breakdown of what your spouse gets and now what the case is. And remember, we are talking about when we were doing in chapter 20, we have the right of election, which is reserved for a surviving spouse. And what if your spouse dies? Well, if you were married before May 28th, 1980, your spouse has a right to all the property that you own during your lifetime. If you were married after May 28th, 1980, well, you only have to leave your spouse 1/3 of your stuff. All right, that's called the right of election. The rest you could leave to your girlfriend. Took you guys a second to get that, huh?
I'm trying not to laugh. I'm sorry.
I'm trying to break things up every now and then, throw a little joke in there for you guys. I know this stuff is boring. I'm just trying to, you know, mix it up a little bit, make it a little interesting. All right. So let's highlight the first 3.5 lines there under dower and courtesy rights. Or did we already highlight that? Did we jump ahead earlier and we do that?
You did.
All right.
Yeah, highlighted.
So yeah, we highlighted the first 3.5 lines under dower and courtesy rights. Basically up until the point where we said New Jersey abolished the creation of any new dower or courtesy rights. And the rest of the paragraph and those bullet points and everything just goes over what I've just explained. Who gets what? Who needs to sign documents? Well, who needs to sign a listing agreement if only one of the spouses is listed as the owner and you were married on January 1st, 1980?
They both.
They both have to sign it, even if only one is listed as the owner. What if you were married on December 1st, 1980, and only one spouse is listed as the owner on the property?
Only the one spouse.
Only the one spouse listed as the owner needs to sign those relevant documents. But I'll always advise people, I'll always try to get everybody to sign it anyway. Unless you get one spouse that's like, no, that's not their property. That's strictly mine, you know. If they're making a big deal out of it, and I see, well, when were you married? You know, that'll be my next question. Because if they said they're married after May 28, 1980 sometime, then I'm not going to sweat it. I'm not going to make a big deal out of it. Although it's a good idea, because you never know what's going on with joint marital assets. Maybe the spouse does have an interest in that property. It's always a good idea to get the other spouse then to sign something that's called a quitclaim deed. And we won't get them to sign that. The attorneys will get them to sign it at the closing table. But once they found out that owner is married. All right, encumbrances. What is an encumbrance? Encumbrance is a claim, lien, charge, or liability attached to and binding on real property. Let me ask you a question. Before we go over any types of encumbrances, without knowing what an encumbrance really is so far, if I were to jump on your back, are you encumbered by my weight? I'm holding on to you. If I jump on your back, I'm holding on to you. Are you encumbered by my weight?
Yes.
Yeah.
Now, can you still move around?
Yeah.
Yeah. It's going to be a lot harder to move because you got my weight holding you down.
Yeah.
But you could still move.
Okay. Yeah.
So I want you guys to have that visual in your head. If real estate is encumbered by something, can you still move it? Meaning sell it?
Yeah.
Yes.
Yeah.
It's just a lot harder to.
Yes.
So I'm trying to give you that comparison there. All right. And that kind of a reasoning. So here are different types of, or let's talk about encumbrances a little more. An encumbrance is anything that limits its use, value, or title. A lien is a financial claim on property. A mortgage lien is another example of a financial claim, and so is a tax lien. Lawsuit judgments. We also have physical or usage encumbrances on properties too, like deed restrictions, easements, licenses, or encroachments. Okay, so these are all encumbrances. Liens or physical and usage encumbrances. These are all forms of encumbrances. If I put a deed restriction that says you can't have alcohol on the property, is that an encumbrance on the property? Is that weighing it down?
Yes.
Is that making it
Yeah.
harder to sell it? Is that affecting its value? Yes.
Yep.
If I put a restriction that I'm selling you a property, but you can't use it as a gas station, it's a restriction. It limits its use or value or title. So therefore it's encumbered. All right. So let's highlight the first line. Encumbrance is a claim, lien, or a claim, lien, charge, or liability attached to and binding on real property. And then let's highlight number 1 and number 2 in that numbered list at the bottom of page 95 under encumbrances. Lien's a financial claim, and then there's physical and usage encumbrances that include deed restrictions, easements, licenses, and encroachments. Here's a little brain teaser for you. All liens are encumbrances, but not all encumbrances are liens. That's true. Let's translate this in our head while we read it. All liens are encumbrances. All financial claims are encumbrances, but not all encumbrances are liens. Okay, so let's translate this. All financial claims are encumbrances, but not all encumbrances are financial claims. When I read a question on exams, I try to translate it in my head like that so I could better understand what they're asking of me. You see how important it is to understand the basic terminology. What is a lien? A financial claim on property, like a mortgage, tax, or lawsuit judgment. Financial claim. Okay. It'll help. If you guys take that approach, it'll help you a lot when taking exams. All right, in this slide, we could see lien is a financial claim on property. Liens can be voluntary, which is something you wanted, or involuntary, something you don't want. Liens could also be general. General, look at me guys. When I'm talking about things in general is a wider scope. You see I'm going like this with my hands, it's a general. When talking about stuff in general is a wider scope. It covers a lot more things. We're going to hear general a lot. General liens is a lien that affects all the property that you own. We're going to talk about there's different appraiser licenses later on. We're going to be using the term general a lot. And anytime we hear of what about license types? Or you could have general agency, right? You could be a general agent or a specific agent.
Yeah.
Specific agent can only do one thing. A general agent can legally bind their clients to a contract. So anytime we hear the word general, it covers a wider scope. So a general lien affects all the property you own, whereas a specific lien is a narrow scope. It only affects one property. the property in question. So here on the left at the bottom, I have a couple images here. Some examples of specific liens are utilities. You don't pay your utility bills. It only could affect that one property. Special assessment tax, that's a tax. That would only affect that one property. An ad valorem tax, that's the general real estate property taxes that everybody pay. If you don't pay your property taxes, it only affects that one property that you didn't pay the taxes on. Your mortgage lien, if you don't pay your mortgage, it only affects that one property. It's a specific lien. Construction liens, also called mechanics liens. If you didn't pay a contractor for work you did on the house, that only affects that one house. All right. I'm not sure what they're talking about vendors, but don't worry about that. Now, general liens affect all the property owned. And here's some example of general liens. Somebody sues you and gets a lawsuit judgment against you. They could take that judgment, and if they find out you own many properties, they could put liens on all those properties. What is a judgment? It's a decree from a court that says you owe someone else money. That's it. So now if I find out you own property, I could take that judgment and turn it into a lien against each property that you own, trying to claim it until the judgment's paid. Estate and inheritance taxes, deceased person's debts, corporation franchise taxes, your IRS income tax. If you don't pay your IRS income tax, can the IRS come after any property that you own to get paid?
Yes.
Here, they sure can. And let me tell you to what degree they can. They could put you in jail. And they'll count each day in jail as so many dollars until you've paid back all the money. And it affects your real property and your personal property. Okay, so we have an understanding of voluntary and involuntary and general and specific.
Voluntary.
Voluntary is the lien you wanted. You wanted to get a
That would fall
mortgage
under
loan on the
mortgage?
house. You went out of your way to get that loan on the house. You filled out a loan application. You put together your tax returns and your pay stubs and anything else the bank wanted. You may have even paid appraisal fees and all kinds of application fees so that you could get this loan. If you went out of your way to get it, it was voluntary. Involuntary is something that you don't want, like property taxes. Who the hell wants property taxes? You have to pay them, but
Yes.
they're an involuntary lien. Now, property taxes, are they general or specific?
Specific.
Specific. It only affects that one property. So property taxes are specific involuntary liens. You guys got it?
Got it.
So let's highlight under liens. A lien is a financial claim on property that provides security for debt or obligation of the property owner. And then the last sentence, liens are classified either as voluntary or involuntary and general or specific. Highlight, a voluntary lien is created by the property owner. Involuntary lien is imposed without the owner's consent. Yeah, let's adjust this slide with that definition. How about that? I'll do a tweak here. There we go. Voluntary lien is created by the owner. Involuntary lien is created without the owner's consent. without the owner's consent. All right, that's a better definition for it, I think. All right. Ooh, fancy transition. Look at that. All right. Encumbrances. Oh, wait, let's also highlight general lien affects all the property someone owns. Specific lien is placed against one parcel only. What did I have in the last slide? Affects all property owned. Placed against one parcel. Yep. Okay. So encumbrances, liens and other kinds, they run with the land. What does it mean when it runs with the land?
It can take.
It passes from one owner to the next.
I was gonna say it literally runs with the, it continues.
Okay, well, an encumbrance, well, anytime you hear the term runs with the land, that means that whatever it is that runs with the land, if you transfer the ownership to someone else, whatever is attached to the land or runs with the land goes with the land. Liens attached to properties, not to the property owner.
Okay.
They
No.
attach to the property, not the property owner.
Yes. So
Really?
if you're a buyer and you're purchasing real estate, wouldn't you want to make sure that you're aware of any liens that are on that property to make sure that the owner pays them off before you take possession of it? Because if you don't, then those liens pass with the property and now they're your responsibility.
But wait a minute. What about the person who defaulted on the payments?
You're buying the property. It's your responsibility to do your own inspections of the property. Now, most time I talk about home inspections, people are thinking about, well, you get a home inspector and they check to see that the house and everything is working and the roof isn't leaking and this and that. Well, yeah, that's one type of inspection. We have a lot of types of home inspections. We do a title search. A title search. What does title mean?
Ownership.
Ownership.
So a title search, let's put it in English, is an ownership search of the county's records and any documents that are attached to it. So if somebody has a lien on the property, you would discover it if you bothered to look. And now you could tell the owner, well, the owner promised to deliver that property to you free and clear of any liens or encumbrances. So they have to clear them up. So you're going to want to make sure that they clear up any liens in that property before you take ownership. This is all part of the real estate process. Title search. As we get closer towards the closing, towards the end of the process is when usually the attorney will order title search and survey, but the owner or we can order that too.
So the owner, let's just say the owner has a lien, like a tax lien against his property. He can't use the equity that he's gaining from selling the home to pay off that said lien, and then it's free and clear?
No, he can.
Oh, he can. Okay.
You can. But we just need to make sure that the closing agents then have that all written out.
Got it. Okay. It just has to be disclosed.
Yeah.
Okay.
Yeah, that's fine. Look, when an owner is selling their property, most homeowners don't have that property owned free and clear. Not unless they've been older and they lived in the house for a long time and they paid off the total mortgage. There's no mortgage on the house. They own it free and clear. I have no loans outstanding on the house now. Short of that, most people have some sort of loan on their house. So when they sell the property, how is that loan getting paid off? From the proceeds of your purchasing it. You're getting a loan to buy it. That loan, that money gets transferred from the lender to the closing agent, which is either an attorney or title company. And they have that money sitting in a bank account. They're going to pay off that existing lender's loan with that money before the seller gets their profit or proceeds from it. All expenses need to be paid first.
Got it.
And if there was another lien, maybe from a lawsuit judgment, because somebody sued them and put a lien against the property, if we were aware of it, which we should, because we should have gotten a title search, we want to make sure that that's going to get paid off out of the proceeds as well. Otherwise, we don't take possession of that property. Because if we do, we just bought that house with a lien. That was stuck.
Yeah, big time.
Now, when you do a title search, a lot of times we get title insurance. If title insurance, the insurance company does a title search to see if there's any liens on the property. And if they missed something, they didn't discover something, they missed something in the records, but you paid for the title insurance, the insurance company would have to pay off that lien. You wouldn't be responsible to. That's why it's important that we usually get title insurance as the buyer. Right? Because if any liens pop up later that we were unaware of, we're insured. We don't care. Right? So liens, they could be voluntary. And here's some examples: mortgage loan or a home equity line of credit. These are examples of voluntary liens. Some examples of involuntary liens are real estate taxes, unpaid federal income taxes, lawsuit judgments, or unpaid child support. Okay. Now, I have listings here too. Real estate taxes are specific liens. You don't pay the real estate taxes, they can't touch any other real estate that you own. If you don't pay your income taxes to the IRS, those are general liens. They could come after all the property you own. Hell, they could come after you. Lawsuit judgments are general liens. They could be turned into liens against any property you own. So can unpaid child support. Now, when you've paid off a loan, if there's a lien attached to the property, how do you attach a lien to a property? You have to record it in the public records with the ownership documents, which are held in the county courthouse, where all the ownership documents for the real estate are kept. When you paid off the loan, they do not remove the lien. That lien is there forever in the public records. Anytime a document is added to the public records, it's there forever. They just add another document to the public records called a satisfaction of a lien. So now anybody who's searching the public records of that property, they could see, oh, there's a lien on the property, but nope, oh, we see it was paid off, because there's another document there called the satisfaction of lien. And if you were to match up all the documents that are in a public record, you could make sure that you got that property free and clear now. All right, any liens on the property create what's known as a cloud on the title. Cloud on the title, what does that mean? Well, I want you to picture a dark thunderstorm cloud hovering over the house. You want to buy a house that's got a dark thunderstorm cloud hovering over it all the time? Or do you want to make sure that owner clears it up and lets the sun shine in before you buy it? You want them to clear up that cloud, whatever's causing that problem. So the term cloud on the title means ownership, cloud on the ownership is indicatory or indicative of a problem pertaining to the ownership of that property. And when you hear cloud on title, think of a dark thunderstorm hovering over the house. We need it cleared up. What's causing it?
A lien.
Now, what determines the repayment order of liens? Priority of liens, you know what? Let's word this in a different way. Liens. Priority of liens, or lien repayment order. I'm gonna put it that way. Lien repayment order. So what determines the repayment order, the order of which liens get repaid? Well, they get repaid according to their priority. And the priority of liens determines the order in which they are repaid in the event of foreclosure. So what establishes the priority of the lien? The priority is determined by the date of recording in the public record, with the exception of two things. Tax liens, which always jump to the head of the line, because there's two things in life that are certain: death and taxes, and taxes always need to be paid. So taxes always jump to the head of the list. And a mechanics or contractor's lien, which it's not dependent on the date of recording in the public record, but it's retroactive back to the date that the materials were delivered or the work was performed, whichever happened first. Here, let's give a little example. Can you guys see the whiteboard?
Yes.
Yep.
Okay. So let's just say that we have a house that's getting foreclosed on. And in the foreclosure, they're getting $300,000 for the house from the sale. Now there is there's a loan balance of $200,000. That's the first loan. And there is a $50,000 balance on a second loan. The first loan was recorded when the house was purchased on, I don't know, January 9th of 1980. Hold on, we got a little background noise. Let me mute that. Okay. And so then this one, the second loan, was recorded the next month. So 2/9/1980. All right. And then we have let's see. Usually people get 30-year loans. That loan should have been paid off by now. Let's make it 2000. Let's make that 2020 or 2000. Forget about the 1900s. They're long behind us. 20. All right. Then there's a there is a $50,000 lawsuit judgment, which was recorded on 6/5/2012. And then there is a $10,000 mechanics lien that was recorded. Well, let's say that it was recorded 7/5/2012, but the work was performed 1/1/2011. Wait, that's not going to make sense. 2012, 2020. Shit. I'll do this. 2010. So, who gets paid back first?
The one who recorded the judgment.
What? Why is that?
Because it's on record.
That was a 2012 though. Liens get repaid back according to their order that they were recorded in the public record. And January 9th, 2010 comes before 6/5/2012. So this one gets paid back first. So this one gets paid back first. Then this one gets paid back second. And then how much money we got left over so far? There's a balance. There's a balance of 50,000 left. Now who gets paid back first out of these two?
The lawsuit.
The mechanics lien. Because even though they recorded it 7/5/2012, it's retroactive back to the date that the work was performed or materials were delivered, which was 1/1/2011. So the mechanics lien will actually jump up in front of the lawsuit judgment. So now they get paid back. There's a 40,000 balance. So that lawsuit judgment, they would get paid let me see. They would get paid 40,000 and the remaining 10, well, they're SOL out of that, but they still have to chase after that person who owed the money. But they could get paid back 40,000 otherwise. But that homeowner that's selling this property, or this was at auction, sorry. This is what determines the order in which who gets paid back first. This is how it works. Now, if there were taxes that were unpaid and there was owed 20,000 in taxes, taxes jump up even before a first mortgage loan. They got to get paid back first. Just wanted to give you guys a little visual on how that works.
Okay.
All right, so let's go back this one here, and let's highlight now. Under effects of liens on title, highlight encumbrances, liens, and other kinds run with the land. That means they go with the real estate and are still binding even after the sale. See that at the bottom of the page 96? Then we're going to highlight liens attached to the property, not to the property owner. Next, on page 97, we'll highlight the priority of a lien determines the order in which the debts will be paid off in the case of foreclosure. Real estate taxes and special assessments, and then stop there. Then go to the line just below it and continue highlighting, take priority over all other liens. So that way you only have highlighted there, real estate taxes and special assessments take priority over all other liens. Okay? And then go to the next line below it and highlight priority is normally determined by the date of recording in the public record of the county where the property is located. At the bottom of the page, they give an example of a mortgage lien. Highlight mortgage lien is a voluntary lien. And then turn the page. And then we got a title here, construction lien. Highlight the title construction lien, also known as a mechanics lien. So basically a contractor can place a lien on your property if you don't pay them back. I like the last sentence under that too, that construction liens are unique in that they're retroactive to the date when the work in question originally began or when the materials were delivered. I explained to you guys what a judgment is, so we're not going to read that. A judgment is just a judge passing judgment, rendering a decision saying you owe this person money, and then they put it on paper. It's one thing to have a judgment, it's another thing to collect it, right? You can't get blood from a stone if the person has no money. But I got a piece of paper that says you owe me money, you got to pay me. But I got no money. Guess what you get? Nothing.
Property.
No money.
The person got no money, but you got a piece of paper that says they owe you money. You get nothing because they got nothing. You have to wait for them to get something someday. If they end up buying a house, you could turn this judgment into a lien against their house. And then hopefully when they go to sell that house, nobody's going to want to buy it with a lien on it. So you could be pretty sure you'll get paid back. Or you could take this lawsuit judgment. Here's a little inside tip for you. If you're ever going to sue anybody ever in your life, or if you already have a judgment against somebody and you're having trouble getting paid, you can try to get their wages garnished so that your judgment gets paid back. Or check this one out. This one is really neat. Go to the sheriff's department. Call up the sheriff's department. You could take a lawsuit judgment to the sheriff, and the sheriff will use their investigatory tools to try to track down any assets owned by the person who owes you money. And if they could find a bank account, a car, or anything in their name, the sheriff can seize it and make sure you get paid back your money. All for a nominal fee of 10% of whatever they recover. The sheriff's officer gets, or the sheriff's department gets to keep 10% of whatever they recover. But isn't that interesting? Did you guys ever know that? You could have the sheriff's department act as your guy who's going to be breaking arms in order to get the collector, your own collection agency. Could be the sheriff's department.
Quick question.
Not going to be breaking nobody's legs or arms, but but that's how they could get it. They could actually take the money directly out of your bank account.
Do you have to pay them a fee if they do that?
They get 10% of whatever they collect, whatever they recover for you. So it is a steep fee, but if you're not getting anything otherwise, it's a way to
Better
collect.
than nothing, yeah.
So. All right, let's see. Go down to list pendens on the bottom of the page. And we're going to highlight the title, list pendens. Now, what is a list pendens? I got this on a slide here in front of you. It's a public notice of possible future legal action, that legal action being foreclosure, that is pending and may potentially affect title to a specific parcel of real estate. It gives the world notice. It gives notice to all interested parties, including prospective purchasers, that someone has an interest in the property. When you fall behind on your mortgage payments by more than 2 months, the lender will usually file a list pendens in the public record. It puts the world on notice of any parties that are interested in that property, that there's someone else that's owed money by the property owner. So if you fall behind on 2 months on your mortgage, anybody who searches the public record on your property can see you're behind on your mortgage payments. Would it be helpful for you guys if you could get a database of everybody who's behind on their mortgage payments so that you could try to approach them to possibly sell their property for them? Maybe they're in danger of losing that property. Hmm. Or for an investor to try to make maybe an offer on it.
And flip it.
Hmm. Well, I give you two resources right here, njlistpendens.com and realtytrack.com. These are two resources where they have people down at each of the 21 counties in where they keep the property records. And anytime a list pendens is recorded in a public record attached to properties, any property, they add it to their database, which then they sell access to that database to people like us, who then can send a mailer out. I don't suggest you go knocking on anybody's front door. Knock, knock, knock. According to my records, you're behind on your mortgage payment. So what the hell are you doing on my porch? Get the hell out of here. They may punch you in the nose, right? Not the best approach. Also, don't go calling them.
No.
If you're behind. Look, if you're behind on your debts, what would you do if a stranger calls you out of the blue? Yes, according to my records, you're behind this much on your mortgage payments. And I'm a real estate agent here to, they're going to be like, wait a minute, wait. How do you know I'm behind on my mortgage? How do you know my financial information? How'd you get that information? You know, this person's going to be pissed. And why are you calling me? Right? A better approach would be send them a postcard or something in the mail. Behind on your mortgage payments? We can help. It's a soft approach. It doesn't seem like you're being overly aggressive towards them, right? Because remember, with every action, there's an opposite and equal reaction. And that includes in humans and personality. If you're aggressively going after somebody, they're going to be aggressively backing up. Doesn't it work that way in relationships? If you're really aggressive towards a lady, well, she's gonna be like, whoa, this guy's a freak, you know? She's gonna be backing up. But if you take that soft approach and you get them to come into you, and then you can meet right in the middle. So you're gonna do the same thing in business. You know, you don't aggressively go after this person, you know, is behind in their mortgage payments. Maybe say, send them a mailer. Behind on your mortgage payments, we can help. Just give me a call, right? You're trying to pull them in. We'll reel them in, right? Yes. Okay. So we're gonna also highlight, go down 4 lines where you see list pendens in bold. And that next sentence you're gonna highlight that says a list pendens is not a lien, but rather a notice of possible future legal action against the property.
There are a lot of questions on this in the exam.
On what?
On this liens.
You get a couple questions on it.
Oh, gosh, they're
Now-
so confusing.
What are you confused about?
Like to differentiate this, you know, the specific and general lien, or should I just learn it by heart? Which one is which?
Well, yeah, pretty much. A specific lien, but no, just go by this. Anytime you hear the word general, you see me doing this. When we talk about something in general, and when talking in general, you do this, right? In general. Well, wait a minute. In general, I could hold more stuff. That's in general. This is a wider scope. If we're talking about something specifically, it's a narrow scope. It only affects one property. In general, it affects all property.
It's broader. Yeah.
Specific is narrow scope, so it only affects one property.
Okay.
Okay. So anytime you hear in general, go like this. You do that with your hands. Go in general. We're talking about things in general. General is a wider scope. You can feel that. But specifically, we're talking about something. We're talking about one item specifically, right?
Yeah.
Hopefully
Okay.
that'll help.
Yeah. Thank you.
You're welcome. And you know what voluntary is, right? Something you wanted. Involuntary, something you don't want. All right. Easements. Easement is a right. Can someone take away your rights once it's been established that you have them?
No.
No, they cannot. They're your rights. You have the right to remain silent. And if you give up that right, oh, can you give up your rights?
Yep.
Yeah.
Yes, you can. Nobody can take your rights from you, but you can give them up. So an easement, we're going to go over a lot of different types of easements now. An easement is a right. So we're going to highlight that on page 99 at the top of the page, the first sentence, and we're going to underline the word right. A right acquired by one party to use the land of another party for a particular purpose is an easement. So if you give someone a right to use your land for a certain reason, can you take those rights away from them?
Yeah.
No, we just went over. You can't take away. Can someone take away your rights?
Yeah, but like if you're like in the case of the government, like if you're by the waterfront and they take away the land that's by the water that you had, isn't that technically taking away your rights because you had the right to own that?
Well, eminent domain is the power of the government to take away property from one person if it's for the greater good of the general public.
Yeah. But I'm saying, isn't that?
Well, hold on a second. They're taking your land.
Yeah.
Now your rights come with the land.
Oh, okay.
But they're not just taking your land. They have to justly compensate you for it. So they got to pay you for that too.
Right.
So this is like saying like if the FBI wanted to use your house for a stakeout or something,
They would have
And
to ask you permission.
they actually, but you can basically say at this point, like at one point in time, like, I don't want to do this anymore. Get out of my house. They got to say, we got to use your house till we're finished, basically, right?
No, it's your property. You have the right to tell them to get the hell off your property. You didn't have to let them on your property to begin with. You could slam the door in your face. You could in their face and say, get lost.
Okay, so that's not part of an easement, I'm guessing. Them acquiring your property for a specific use. Okay.
No, if you gave them permission, easement is a right. You're not giving them rights. You're giving them permission.
Okay.
You know what? Let's stop right now. Let's turn the page. Go to page 101. On page 101, turn the next page. Go to page 101. You see where it says the words licenses? I want you to highlight the title, licenses. And let's highlight the first sentence and highlight and underline the word permission. A permission to enter the land of another for a specific purpose is a license. Easement is a right. License is permission. Nobody can take away your rights, so nobody can take away an easement once it's been granted. But if you give somebody permission to enter your land for a specific purpose, that permission can be revoked. Just like your driver's license, that's permission to drive. Can your driver's license be revoked?
Yes.
Yes.
Yeah.
Now, licenses are usually not in writing. They're usually verbal. Hi, neighbor. How you doing? Feel free to come over to my house. You could use my pool anytime you like, even if I'm not at home. What did I just do? I granted you a license to use my property for a specific purpose, to use the pool. Now we get into an argument. I don't want you on my damn property no more. What did I just do?
Revolt.
I just revoked your license. It's as simple as that. But easements, they're usually in writing and they're usually added to the deed themselves and sometimes even put onto surveys. Okay. So an easement is a right acquired by one party to use the land of another. And there's different easement types: easement appurtenant, easement in gross, easement by necessity, easement by prescription. We have party wall easement agreements. And we're going to go over how to create an easement and how to terminate one.
And so just to think of it, if you want to think of the easement versus the permission, just say the easement is just more formal and in writing.
Well, here you go. I got a slide. I just changed slide. Look at this slide. Easements versus licenses. Easement is a right acquired by one party to use the land of another for a specific purpose. It's usually in writing, written into the deed itself, and cannot be taken away. You cannot revoke somebody's rights. You can revoke their license. License is permission to enter the land of another for specific purpose, often verbal, and can be revoked at any time. Boom. Good study guide right there. Because I not only tell you the two and have you highlighting them, I'm comparing them. So an easement, once again, is a right acquired by one party to use the land of another for a specific purpose. Easements run with the land. That means it passes on to the next owner with the change of ownership. So if you gave one person, if one person has an easement to cross over your land, and then that land is sold, that new owner has to honor that old easement. They can't take away those rights that that person already has to use that property. So a party also has an easement right in the air above the land or subsurface easement rights to what's beneath it. The holder of an easement only has rights, not an estate or ownership interest in the land over which the easement runs. So easements fall into two categories. They could either be appurtenant or engross. So an easement appurtenant is an easement that grants the rights to the owner of an adjacent parcel of land owned by different parties. Okay, what does the word adjacent mean? It's your next door neighbor who their property is touching yours. It's not the guy across the street. Adjacent is any piece of property that's touching the other. It's abutting to the other. That's an adjacent parcel. So if you got two or more, here, let's look at this one. You see this image here on screen?
Yes.
We have easement appurtenant here for lot owner A on the right, lot owner B on the left. Lot owner A gave an easement right for lot owner B to cross over their land to get access and use the lake that's on lot owner A's property. Now, if lot owner A sold their property to somebody called C, they sold their property to, they're now lot owner C. All right, so there's a new owner to lot A. They sold their property to a new owner. That new owner has to honor this easement appurtenant right, allowing this guy, lot owner B, to still keep crossing over his property to use the lake. Can't take away those rights. Can't put up a fence over here to prevent him that direct access.
Why not? I'm curious about that.
Because
Does
lot
that-
owner B has a right and you can't take away someone else's right. When
I
you
can
bought,
understand if it was a easement of necessity or engross, but a tenant is
appurtenant. It's very appurtenant that you obey their rights. It's very appurtenant that you don't try to take away someone else's rights. That's very appurtenant.
I understand the necessity for the other two. Like I said, engross, I get it. The necessity, I understand that. But that one is just to lose a lake. I mean, just gain access to my lake, which you don't is not a necessity.
Stop. It does not have to be a necessity to it. Hold on a second. I don't want to start using that word necessity because there's a type of easement called by necessity. I don't want to confuse right now. How did this easement get created? What is an easement?
Formal writing that gives you
It's
the
a
right.
right of one party to enter and use the land of another. So who gave lot owner B that right?
Owner A did.
And owner A.
Did. Once owner A created that easement right, giving B rights to cross onto their property, they cannot take it away. You gave them that permission. If you didn't want somebody to use your lake, you should have never given the permission to begin with.
And that lasts, it runs, like you said, it runs with the land for every.
Okay, so now lot owner A sold the property to somebody else. So now there's a new owner of lot A. They still need to honor the easement right of the neighbor. When lot
Yeah, that
owner
was my
A-
questioning.
Hold on. When lot owner A bought this property, it's not a surprise. They were aware that there's an easement on the land. It's not a surprise to them. If you didn't
Okay.
want somebody, if you had a problem with that, then you should have never bought the property.
Okay, I got you. I
Okay?
got you. Yes.
What happens if lot owner B sells their house?
Well, the easement right that they have to cross on a lot owner A's property and use the lake runs with the land. So the new owner of lot B can still have access to the lake. This is what we mean by these rights run with the land. Now, anytime you have an easement appurtenance, the properties have to be touching each other. In this case, both properties are touching each other. They're abutting up to each other.
Okay.
And there's always a dominant estate and a servient estate. The dominant estate and a servient estate. So the dominant estate is the one that benefits from having the easement right. And they're the only ones that can terminate or give up their rights. An owner cannot take away your rights, but you could give your rights up. So in this scenario, lot owner A and lot owner B for the access to the lake, who's the dominant estate and who's the servient?
Dominant is A.
A will be dominant. A.
No.
B
The
is
dominant
the
is B
because look,
because they benefit from it.
the dominant estate's the one that's benefiting from the easement.
Hmm.
B is
Oh.
benefiting from the easement because they get access to the lake.
Okay.
So they're the dominant. Okay, I'm trying to figure that out.
Lot
So,
owner,
I'm trying to
lot-
comprehend.
think of it this way. Lot owner A is the servant. It's servient, but they're acting as the servant. Yes, you could cross all over my property to use it for your benefit. Is there anything else I could do for you while you're at it? You know, if you want to look at it this way, lot owner B is the bully. They're the dominant one. Although they're not bullying anybody, they have a right to do it. But you know, if somebody's dominant, they're the one that's trampling all over your property, and you're servient. You're like, yes, yes, my lord. Right? So think of it that way. The dominant estate is the one that benefits, and the servient is the owner of the property whose property is being used, that's getting walked all over. So lot
Okay.
owner A is the servient whose property is being used, and lot owner B is the dominant who's using it.
So is it possible to say no?
No. Because if lot owner A was telling lot owner B that they can't use the property, they're violating their rights.
Yeah, because the lake is basically like community owned, correct? Something like that. It's
No,
not private
no, it's,
land.
it's this little lake is on lot owner A's property completely. It's not on anyone else's property. You could have a pond or a lake on your property that's not attached to any other body of water and is only solely on your property. Well, then that's your lake.
So why would I share with someone?
Good question. Good question. So you're saying, why did lot owner A create that easement? That's another way of saying your question that you just asked me, right? Why did
Yeah,
lot,
I mean,
why
But
did
he
lot
needed-
owner A create the easement to give lot owner B the
Yeah.
right to cross over their property and use the lake?
does
That's
he
the question.
pay
Okay, here.
lake fee?
Let me answer that. This all used to be one property. and there was no house here. Lot owner A subdivided his property into 2 different lots and built a house. And he's selling the second property, and he's scratching his head and he's like, wait a minute, is there a way I could get more money for the house and make it more valuable? If I were to give them access to the lake, would that make that property more valuable?
Oh, yes.
Mm-hmm.
Oh, maybe they created it that way. I'm just spitballing ideas here.
Got it
Okay.
now.
Okay.
And easement, it's a document, correct?
Well, no, easement is a right, but it will
Oh,
be.
no, I mean, yeah, like, but.
Yeah, it'll be in writing. It'll be in
Yeah,
writing.
Right, written one, okay.
Yes, because the easement agreement has to be put in writing. It's usually written into the deed itself, but sometimes you'll see it on a survey by a surveyor. Look, the surveys sometimes show utility lines where utility lines run for utility easements that may be underground, which is our next one, by the way. An easement in gross. So there's 2 categories of easements. They're either appurtenant or in gross. An easement in gross is a public utility easement. Now, if the need for this easement were to cease, the easement would cease to exist. Now, that statement would only apply to this type of easement, to an easement in gross. If the utility company that has these lines running across, they got the power lines running across the property, right? Let's say that they came with a new way to reroute because they built a power plant somewhere down here. So they don't need to have these lines run anymore. All the properties up here are being run off a separate grid. So they don't need any of these power lines, are not being used anymore. Well, if the need for the easement were to cease, then the power company's easement right to be on your property would cease to exist as well.
Yeah.
That only applies to an easement in gross, though. You need to know that statement because it'll be on an exam too. These different types of easements, you need to understand them. So who gets an easement? What is an easement in gross? It's a utility easement. So down at the bottom of page 99, I want you to highlight easement in gross, and then highlight the last sentence there. If a need for the easement were to cease, the easement would cease to exist. And right next to the title, utility easement. It's a utility easement. Just like this. It's a utility easement, a public utility easement for like sewer lines, gas lines, cable TV, FiOS, any kind of public utility, gas lines. We would not have a modern civilization without an easement in gross. Let's also back up and under easement appurtenant, highlight the first sentence. And then underneath the picture that you see on 99, highlight the first paragraph that says, for an easement appurtenant to exist, there must be 2 adjacent tracts of land owned by different parties. The tract over which the easement runs is known as the servient estate, and the tract that's to benefit from the easement is known as the dominant. And then just below that, highlight an easement is said to run with the land, and underline the words, run with the land. Next up, we have an easement by necessity. When there's a necessary easement to gain access to landlocked properties for the purpose of ingress and egress. Ingress is Latin for entrance and egress is Latin for exit. So if your property is completely surrounded by another property, how do you get in and out of it? So let me see. I got a whiteboard here for ingress and egress. Let me just show this real quick.
Well, the figure that we just looked at had a good example of that also.
It doesn't have a good example of it. It has a bunch of trees in front of the house, and well, how come you can't just cut down the trees? You know, let me give you some better example for types of easements, so that nobody argues the points. All right, I have this whiteboard here where I created a thing talking about the types of easements. Okay, one thing is, when you own a property, on the front of your lot, the first 6 feet of your property, your city has a public easement right to it. Where they could put in a sidewalk if they wanted to, and then there's that little patch of grass. Sidewalk is usually about 4 feet wide, and then there's that little patch of grass here. Or the city can come up, drill a hole in front of your house and plant the tree. They don't need your permission to do it. Also, this is the area where the utility lines usually have the on-off switches to turn on and off the gas or the water to your house. If you don't pay the bill, you'll see the pipe over here where they could turn it on and off. Now, an easement by necessity. Here's one. I got a couple diagrams of this. You got lot owner A and lot owner B. Lot owner B's property is completely surrounded by lot owner A's property. So they would have created a driveway here so that lot owner B can get to their property or get off of their property. Now, lot owner B cannot park their car here because that's lot owner A's property. They can only use this driveway or this road to get access to their property, which is completely surrounded by someone else's. It does happen. So that's what they mean by ingress and egress. Now, who's responsible for shoveling the snow on that road?
Lot owner A,
Why do you say it's lot owner A?
because it's their property.
That's a good reason. If that road starts falling apart, who's responsible to maintain it?
Could that be negotiable?
Lot owner A, because it's their property.
Their property.
And there's an easement right that B has the right to cross over their property to get to theirs. So an owner A cannot just let the road crumble and fall apart
So
try
they
to
have
try
to.
to screw with B, you know what I'm saying?
Yeah.
Or if a tree falls down covering it, that they just leave it there.
Okay.
If B needs access to it. Let me give you another example of easement by necessity. Shared driveways where you have lot owner A here and lot owner B on the right. These are their houses. Here's their garages in their backyard. But they have a shared driveway. There's not enough land here for either one to have their own driveway that goes to the back. But if they share this space, they could create a driveway for both of them to get back here to break off to their side. So that's an example of an easement by necessity, which is also an easement appurtenant. It's an appurtenant because there's a dominant estate and a servient estate for next door neighbors. But this type of easement is also necessary for the access of ingress and egress.
Time out. Which one is dominant? They both look pretty even.
They're both dominant and servient at the same time.
Okay.
because there's not enough space on either one of their property to get a car back there. They would have to drive across both properties in order to get to their own. So this is kind of unique, but this is pretty common. Go to a place like in the Amboys or in Perth Amboy, you could see this a lot, or in Essex County, you see this a lot. In places like maybe East Orange, where the space is kind of tight. They built the homes kind of close, and the lots aren't that big to begin with. So they have these shared driveways, but they got them everywhere. Every town has properties like this. Every town got them. I'm just talking about towns where you see a lot of it. You know, Elizabeth. You know, you see a lot of towns have this stuff. Okay.
Okay.
Now, can one of these owners, because more of the land for the driveway is, let's just pretend that lot owner B, that more of the driveway is on his property, can he prevent lot owner A from getting back there? No, because even though more of the driveways on his property, he still can't get his own car to his own garage without driving over A's property. So they both have this easement agreement where they both have a right to cross over and use it. Now, as long as the neighbors are friendly and accommodating to this, there's not usually an issue. But sometimes you always get one neighbor that's a jackass that's like, they park their car there. They're like, that's my driveway. You can't park your car in my driveway. I was only taking the groceries out. I don't care. That's my driveway. You want me to put a fence up? Well, you can't. You can't put a fence up because I have a right. Bully. All right. All right. All right. Let's go back to slide. So that's an example of an easement by necessity for the access of ingress and egress. That's what its purpose is. All right. And lastly, we have an easement by prescription. This is one we've mentioned before, we talked about already when we went to chapter 20. Some people know it as squatter's rights. It's when you use someone else's property for a period of time as defined by law, for that prescribed period of time. You can claim ownership of the property that's being used after it's been used for the minimum of time prescribed by law. That minimum prescribed period, that prescriptive period, is 30 years if it's improved lands, or 60 years for unimproved woodlands in order to make the claim. Now, both of these periods will be changed at some time in the law in the future to a 20-year common law period. All right, so right now there is 20, 30, and 60 year on the books. They're going to get rid of the 30 and 60 year period, so it's just a 20-year common law period. But as of right now, it's 30 years for improved lands and 60 years for unimproved woodlands. That's what you need to know for state exams still. Study these periods, not the 20 years, the 30 and the 60. Now, nobody can successfully sue in New Jersey now because of this conflict in the law, but it's eventually going to get changed to just 20 years, whether it's woodlands or improved. But right now, it's 30 years for improved and 60 for unimproved. Now, in order to gain ownership of this property, the use must be continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, the use must be visible, open, and notorious. Now, to perfect this easement, by prescription, it requires that you sue the other party. Just because you've been using someone else's land for a period of time doesn't automatically make you the owner. You have to take them to court, prove that you've been using it for that long a period, and make the claim of ownership. If you don't make the claim of ownership, you're not going to become the owner. Now, if you were only using that property for a period of time that did not meet the full prescriptive period, successors in interest can tack on one person's time to that of the other to reach the amount of time that's required to gain an easement by prescription. I'm going to zoom in right here. I give an example of two lot owners, lot owner A and lot owner A, lot owner B. Here's the property line right here in the middle. This red dotted line, lot owner A put a fence up right here on lot owner B's property, clearly over the property line. If that fence is there for 30 years, he could take lot owner B to court to claim, to perfect that easement by prescription. What is the lawsuit called? A suit for adverse possession.
Okay.
Now, how could lot owner B, now what would lot owner get? He wouldn't get all of lot owner B's property. He would only get, if it's granted by the court, this space in here where he's got the fence. That fence had to have been up there for at least 30 years though. It had to have been against the owner's permission, hostile, adverse to their title, and exclusive used by them. Now let's just, what?
I'm sorry, I was gonna ask you, but if the owner B gave permission to owner A in a form stating that he's giving him permission to have the fence on his land.
Well, you can't gain an easement by prescription with the owner's permission. You see, that's, I have written here on the side, give permission. If lot owner B gave him permission, that's the way he could prevent them from suing him to gain an easement by prescription.
Okay.
Okay. Now,
Okay.
let's just say lot owner A put this fence up here, and that fence was there for 20 years. And then he died and left the property to his son. How much longer does his son need to be living there with that fence up in order to get the easement by prescription?
Another 60, something like that?
Another
60
10
years?
years. Add their 10 years to that of them, that equals 30, get to the prescriptive period. They call that tacking. You're tacking on one person's time to that of the other. All right, so that's how tacking works. Now, to prevent lot owner A from gaining an easement by prescription, lot owner B can take lot owner A to court to get them to remove the fence and put it where it belongs, right on the property line. They could give them permission to have the fence there. Say, hey, listen, your fence has been on my property for the last 30 years. You got to remove it. But I'll give you permission to keep it there till the end of the month. And if I put that in writing and I send it to them certified mail there, guess what? I got proof, right? Or I could have a process server or a sheriff's officer serve them with those documents, giving them permission to keep their fence there till the end of the month, but then they got to remove it. By giving them permission, he reset the 30-year time clock. So he'd have to be there, he'd have to have that fence there for another 30 years in order before they could gain a successful easement. Or he could cut off his direct access. What do I mean by that? Lot owner B can put their own fence right where it belonged to begin with, right on the property line. Cutting off lot owner A's access to this area. If they don't have direct access, your access had to be continuous. He cut off his access.
It'll cause a war over there in that lot.
Oh, yeah.
Well, what do you think would happen? What do you think would happen if he sued you and took ownership of it?
Same thing.
Yeah, we got the Clanfields and the McCoys, right?
Yeah.
Hatfield,
Is that what it is? Clanfield, McCoy? Whatever.
Hatfield, in the court.
Hatfields and the McCoys. There we go. Some kind of redneck name. Yeah. All right, so here we go. Okay, so that's the property. All right, let me see. So I think I covered pretty much that. Oh, now, what if lot owner B put the fence here?
Put
That's
the
fine.
fence where?
So here's the property line, okay? This is the property line. This is the actual property line. Lot owner B is the one that put up the fence and they put it up here.
With the red fence?
Yep.
That's fine. He can put it wherever he needs to. This
Yeah,
is his
it's
property.
on his property.
All right. Now, because lot owner A sees that there's a fence over here, so they're cutting all this grass and they're using all this land. If they're using it for 30 years, can they claim ownership of this land in here?
Yes.
Yeah, because we're still talking about the same scenario, regardless of who put up the fence. See, sometimes in real life, guys, it's not the lot owner A who put up the fence. Maybe it was lot owner B who put up the fence years ago. And maybe he forgot where the property line was, or he was just being courteous. He wanted to make sure that he didn't put the fence up on lot owner A's property. So he wanted to put it inside the property line a little bit. So it's not zero property line zoning. You know, most municipalities don't have zero property line zoning, which means that you're allowed to put the fence directly on the property line. You have to have it in a couple of inches or even a couple of feet.
That was my question for you. How far should it be? A foot in, 12 inches? I mean, how far should it legally
Check
be?
with your local municipality because it varies by municipality zoning laws.
Okay.
But see, these are common issues that we come across. And I got some videos to show you now about easements by prescriptions. I got a lawyer that explains the whole process as well. And it's very interesting. The only problem is